So here we are. CREAN is a children's rights European academic network that today, as we just said before, he's supporting among his activities the organization of seminars and webinars. I will give you a glance of our activities. But in order to introduce it to you, I would like to just briefly refer to the mandate and the mission of CREAN. So it's an European academic network of higher education institutions that are dedicated to children's rights, and is meant to enhance and the collaboration, the exchange and the collaboration among those actors. CREAN today is composed of more than 13 European universities that works together to make children's rights more, I would say, visible, interdisciplinary epistemological field of study, and to strengthen the link between academia, scientific research, and policy development. CREAN acts as a catalyzer, I would say. It's more like here we wrote a platform that is meant to promote and strengthen the exchange of scientific knowledge among its members, but also to disseminate information about training programs that are offered by the CREAN members on children's rights. The objective of our network are, I would say, large and large in scope. But first of all, is meant to promote an attitude that recognizes children as subject of rights, to strengthen the professional ethics meant to respect children's rights, and as a consequence, professional accountability towards those rights, promote children's rights as to resources and participation in the decision-making process, is meant to, as I said before, to enhance learning between advanced programs offered by our members in Europe, produce innovative knowledge, but it's also meant to meet in order to meet the needs of, I would say, learning needs of forming human resources that are working in the field of children's rights, and of course foster cooperation between the university, public institution, NGOs that are working in this field, and European, I would say, international, European, and national level. The means through which CREAN fulfill those objectives are multiple. Here I'm not going to give you a list, just some example. The first one is the biannual conference. The next one would take place in April, on the 25th and 26th of April next year in Geneva. And we'll focus on collaborative research in children's rights, fostering a dialogue between academia and society. The seminars and webinar. Today, you are attending the one organized by the Ludwig Boltzmann Institute, but next week, for example, there is another one on best interest of children that is organized by another partner of the network, the KEKI institution. The Children's Rights Research Symposium, beginning of December, the 4th and the 5th. There is the ninth symposium on PhD symposium is taking place in Antwerp, organized by the University of Antwerp on critical approaches to children's rights. If you are PhD students, don't be too frustrated if you didn't manage to participate in this one. There will be soon another one in June 13 and 14 of June next year, organized by the University of Stockholm. Another example that this year is one of the activities that compose the CREAN portfolio. There is the Children's Rights Moot Court that is organized by the University of Leiden, and the 6th edition, the next one will take place in 2025. Please stay connected and make sure to follow us on LinkedIn, on X, the former Twitter, and through our website. I thank you here for the attention for this little presentation of CREAN activities, and without further ado, I want to open the keynote session on And I would say happy. I'm sorry, I'm struggling with closing my PowerPoint and stop sharing my screen. And I start by passing I need just a technical confirmation. You don't see my screen anymore. Can someone on the other side? Perfect.
We don't see it.
Thanks a lot. Thanks a lot. So I'll open our first initial keynote and introductive session on our discussion on disciplinary sanction regime in youth detention facilities. And I'm happy to welcome our first keynote speaker, Ton Liefaard. Hi, Ton. Thanks for joining us. Ton is a vice dean of the Leiden Law School and professor at the Leiden University, where he holds a UNICEF Chair in children's rights. He teaches children's rights, child law, and juvenile justice from an international and comparative perspective. He published widely on the meaning also of the UN Convention on the Rights of the Child and the related international and regional instruments for the position of children at the national level. Professor Liefaard, Ton, will open the introductory session of our webinar today with a talk on the access to justice in detention and the dichotomy of children-friendly detention. Thanks a lot, Ton. Mic is yours.
Thank you so much, Roberta. Good morning or good day to you all. I will start by trying to share my screen, and I hope you can all see that one. So here we are. I would like to take you to the theme of access to justice for children, but I will start by saying thank you to the Ludwig Boltzmann Institute and CREAN for having me. I very much like to speak about this topic for two reasons. One is that access to justice for children is an absolutely critical element of child rights protection and a field of law that is really emerging and has emerged over the past years. And detention has always been my focus area, one of my focus areas from the very beginning of my academic career. So it's a wonderful opportunity to combine these two topics today for you. Of course, if we zoom in on practice and the realities children face when they are in detention, it's far from being a very pleasant topic to talk about, because there are so many challenges when it comes to children in detention. And there's such a big need for having access to justice that I think it's even a very grim topic to talk about. I would like to end on a positive note, so don't worry. But I would like to start by warning you in a way that the topic of today is rather difficult and challenging. And I hope that together we will find ways forward to better protect the rights and interests of children in detention, because there is a strong need to do so. This week is an important week in the sense that earlier on we celebrated and commemorated the 34th anniversary of the United Nations Convention on the Rights of a Child. And I cannot think of another time in which it was so important to underscore the very core message that children's rights are human rights. So I cannot start talking to you today by flagging that very, very strong message that children's rights are human rights, and they are indivisible and they are relevant for all children in the world. And of course, our thoughts go to the many children that suffer from conflict, but also the children, for example, living in my country who are now maybe waking up with the idea, am I still very welcome in this country if I not belong to this general group of Dutch people? I cannot help being critical there to my own country, and I hope that we will, in the years to come, be able together to really keep sending out this message, because children's rights is something to work hard on and to keep high. And that is certainly also true for children in detention, because children in detention often belong to the most stigmatized groups of society, and not only for the reason that they are detained or they are threatened to be detained, but also because the vast majority of children in detention are already belonging to these groups of society that are most stigmatized, most vulnerable, and often also most disadvantaged. So we are talking about children with an immigration background. We are talking about children with mental health problems. We are talking about children who are living on streets. We are talking about children that are in need of care and protection. But instead of really offering them that, we detain them, and that seriously challenges their rights and their protection. So that core message, that this is a specific group of children that requires our attention, came very strongly out of the United Nations global study that was published in 2019. It was a study that came out of a strong lobby led by NGOs, a big NGO collective, and ultimately Manfred Nowak, of course, very closely connected to the Ludwig Boltzmann Institute and a global leader in human rights, led the study and ultimately made the study into a very rich and informative document that gives us, for the first time, a very good understanding of the phenomenon of children deprived of liberty. And until then, we didn't really have that global image of children deprived of the liberty. So there were many assumptions when it came to the various forms of children in detention, but we didn't really have a global understanding of the phenomenon. The study shows that it is very difficult to get a good understanding, for example, on how many children are actually detained at this very moment. But it was certainly confirming that there is many children across the world. There are many children across the world that are in one or the other way deprived of their liberty. And we give that reality, that status, that deprivation of liberty, many different names. But altogether, children end up in a form of detention in the juvenile justice system, in the child protection system, and that concerns a big group of children detained are actually detained for child protection reasons, and more than 5 million children at least. But also other forms like immigration detention for national security reasons. And also children may find themselves in a form of detention because their parents are detained. Well, the study is rich in showing us the phenomenon, but it also is highly informative because it shows very clearly how the rights of children are challenged when children are detained, and that it is not self-evident that we see children as equal when they are deprived of liberty. In other words, they easily lose their rights, or they are denied their rights, or their rights are simply violated. And then we are talking about basic services to children. We are talking about the protection against violence, and also the more serious forms of ill treatment, including torture. And we are also talking about taking away the child's right to be reintegrated properly into society so that the child can actually play a constructive role. And that is why the global study ultimately concluded that depriving a child of liberty is actually depriving the child of chances of a childhood altogether. It is very important when we talk about deprivation of liberty to define what we mean. And the global study does that as well, and refers to international law. And a definition can be found in the United Nations Rules for the Protection of Juveniles Deprived of Liberty, the Havana Rules. And we are in fact talking not only about the classical closed facilities, or the prisons, or the jails, or the police detention centers. No, we are talking about a much bigger array of placements from which the child essentially is not permitted to leave at will. And that means that if we are talking about access to justice for children, that we really need to be concerned about children in a wide variety of institutions with all kinds of different names, ranging from residential care facilities to hospitals to, of course, also prisons. And in these settings, there are many children that are literally out of sight. They are not visible anymore. That makes them extremely vulnerable and dependent on the institution regime. And that comes with significant challenges. And I think it's fair to say that we are, in this particular context, confronted with what you could call a justice gap. A gap that means that children are denied rights, that children are not seen as in need of having rights, and that children are not given access to justice. So what does access to justice mean? It is a legal concept that really emerged over the past decade. Of course, access to justice is much older, and it is directly related to the human right to an effective remedy in case of rights violations. It is considered to be an element of the rule of law, and therefore it's part of the UN rule of law agenda. And it's also now an element of the Sustainable Development Agenda. Goal 16 specifically refers to access to justice as an important element of sustainable development. But for children, it took us a bit longer to really understand and also embrace the idea that children are equally in need of having access to justice, because their rights may also be at stake. And the Committee on the Rights of the Child has formulated it in a way that if you don't provide access to justice or access to more specifically effective remedies for rights violations, rights do not have that much of a meaning. And they may not only be of symbolic importance, but we cannot really hold those who should protect the rights of children to account. So it's fair to say that access to justice in general is a child rights concept that is an essential element of effective child rights protection. And it is directly linked to accountability of the state and state actors, or those acting on behalf of the state, could also be private actors, to protect the interests and rights, of course, of children. But children suffer from specific barriers. Like adults, they have general barriers like lack of access to legal aid, for example, which has also a financial component. But for children, there are additional barriers. The system where they need to go to in order to secure their rights protection may be too complex, maybe more complex for children than for adults. Systems that are in place to secure access to justice are certainly not developed with children in mind. So how do we make these systems more accessible, accommodating, and ultimately more child-sensitive? Children may also not have a legal right to access to justice. There may be legal impediments for them accessing justice. And more specifically, when it comes to children in detention, there are even more barriers. Sometimes simply the absence of access to justice avenues, simply because it's not provided for in law or in policy, or it's not done in practice. But also the specific vulnerability of children in detention, them being out of sight, the institution being completely intransparent, is coming with specific barriers relating to access to justice. And that is a problem. A problem because of this particular vulnerability of children in detention. I see two roles for access to justice in the context of detention of children. And the first role is to really keep children out of detention as much as possible, because that is the key message that comes from international human rights law when we talk about children, is that children should be protected as much as possible against the negative impact of deprivation of liberty on children and on their development and on their interests, short and long term. And the important access to justice right here is the right to habeas corpus, which is laid down in Article 37 under D of the CRC, the Convention on the Rights of the Child. And it basically means that the child has the right to challenge the legality of the detention. So the child has to be part of the justice process from the very beginning, but it should also be provided with legal avenues and additional support, of course, to use these avenues to challenge the legality immediately or after a certain period of time. And the baseline here is that the longer the child is detained, the more it is required to justify the continuation of the detention. So access to justice is absolutely critical to keep the pressure on the government to justify the detention and the continuation of it. So there's the first important element. The second one is access to justice while the child is detained, because it's likely that there will always be children deprived of liberty. That is, as we speak, a reality, but it will also continue to be like that, even if we manage to finally progress more in terms of shielding children against deprivation of liberty. So if children are deprived of liberty, access to justice is an essential element to secure a child-specific and human rights approach to all children inside a detention center. And there it doesn't matter what the context is that led to your detention. All children, if it's for care reasons or immigration reasons, although that particular category should be excluded from deprivation of liberty altogether, but okay, there's still children in immigration detention, in the child justice facilities, in mental health facilities, in national security prisons, there should be access to justice. And that revolves around information and assistance, empowerment, access to remedies for rights violations, including compensation, transparency improvement, by, for example, bringing in external independent authorities to check in with children as part of their access to justice right. And of course, this is also about including all children who are detained. I'm conscious of time, so I would like to go to my final concluding observations. Access to justice for children in the context of detention, specifically also in relation to for example, discipline, one of the core themes of today's webinar, disciplinary measures, is an absolute essential element of child rights protection. It will allow children to be critical towards the placement of them in a facility. They can challenge the legality of it, but they can also seek help and assistance to adequately protect their interests while they are in detention. And that is particularly needed because of the lack of transparency of institutions, of the lack of access to institutions, for example, also for children's parents. And the reality that in many institutions in the world, there is a lack of avenues to access justice. So it's literally extremely difficult for children to demand attention for their rights. That makes them, of course, very, very vulnerable. It is also a very important vehicle because children are often denied having rights for the sole reason that they are deprived of liberty. And that's either because children are denied rights because they are seen as not as children to start with, but for example as criminals, or they are considered to be in need of care and protection, and that then people think, or authorities think, that they have the best interest of child at heart, so there's no need for access to justice. And that is, of course, a flawed reasoning. So we need to challenge that as well, that also in the context of best interests and placement of children in care facilities, there is a strong need to keep pressure on the system through access to justice. And that is an essential element of the recognition of children as rights holders. We have to acknowledge that there are specific barriers that children have when they are in detention when it comes to access to justice. So they need additional means to find information and to get information, to have access to justice mechanisms, that these justice mechanisms should be accommodating, empowering, responsive, and there should ultimately also be remedies so that altogether those who are ultimately responsible can also be held accountable. The stakes are very high, and therefore it's absolutely critical to further develop this concept for all children deprived of liberty. Thank you so much.
Thanks to you, Ton, for, I would say, setting the scene, enabling us to understand children's rights deprived of liberty and contextualize that within, I would say, the practice, the national, the reality, and the limits, the barriers, and for raising this idea of the centrality of the access to justice for children in detention, to challenge starting the exact, like you were saying, the exact legality of the detention condition. I'm sure we will go back to these components during our Q&A session. Now I take the chance to pass the microphone to our second Our second keynote, Mariama Diallo. Mariama is the coordinator of the Child-Friendly Justice European Network, a dynamic network that is based in Brussels and is composed today of 31 organizations, experts, and academic institutions, which defend the rights of children in contact with the justice system across European countries. She's a passionate expert on children's rights and has over 18 years of professional experience working in international cooperation, including with UNICEF, the French Ministry of Foreign Affairs, and the international NGOs in Europe, Africa, and Asia. With this second keynote, we will have the chance to move to a more practically oriented discussion on applying children-centered justice in the sanctioned facilities. Thanks for being with us. Microphone is yours.
Thank you very much, Roberta. Thank you very much to the CREAN and the Ludwig Boltzmann Institute for Fundamental and Human Rights for this invitation. We are very pleased. I am very pleased and honored to be part of this discussion today and to address actually a very key topic in continuation of the presentation from Ton Liefaard that will be focusing a little bit of one type of disciplinary sanction that happens to children and people in general, but also more particularly children in detention, which is linked which is solitary confinement. So indeed, in our network recently, and in close collaboration with Terre des Hommes and the Global Initiative on Justice with Children, we have been consulting our own members into what practices do exist in Europe and in other regions in the world in terms of solitary confinement. How is it defined? How is it applied? How do children actually experience it? And we wanted to actually share a message, and this is why we have just published this week before this webinar a paper that we put here in the chat, so you can please consult it. It's fresh from the oven, that will give you a bit of a comparative view of solitary confinement across the globe. Today, this is really about a reality check from the field, because as we understood also since the first World Congress on Justice with Children in 2018, and our member DCI, Defense for Children Spain, had organized a series of webinars in 2022 to look a bit more in depth into what practices, but more interestingly about what alternatives could be considered to detention facility that would apply solitary confinement as a measure that would be for punitive measure, but also sometimes for protective measure. So what is solitary confinement? Just a bit of a refresher. According to the UN Special Rapporteur on torture and other cruel, inhumane, and degrading treatment or punishment as harmful practice, solitary confinement is a physical and social isolation of persons who remain confined to their cells between 22 to 24 hours a day. And according to a recent campaign, in 2019, from the Stop Solitary Kids campaign, another definition was given on involuntary placement of a youth alone in a cell, a room, or other area for any reason other than a temporary response to behavior that threatens immediate physical harm. So here we were looking actually what we quickly understood from the paper, and I'm going to give you a bit of a summary of what our findings were, is that solitary confinement is still widely considered as an indispensable tool as a tool for discipline across the world. We have noticed that there is really a lack of uniform definition of solitary confinement, and we really understood that various facilities have different perceptions, or authorities have various perceptions of what solitary confinement means, how it must be applied in practice, various interpretations also of what constitutes solitary confinement, and also the duration of solitary confinement that varies from one country to another quite considerably. We also noticed that there was quite a bit of contradiction between what the law explains of what type of solitary confinement might exist and what the reality on the ground is. There are more or less, in our study, more or less prohibitive laws. And just to give you an example, DCI Spain had researched over 30 countries, and out of these 30 countries, only 4 countries had clearly mentioned that they have solitary confinement as a disciplinary measure. But when they looked more in practice, it appeared that in practice, solitary confinement was actually applied, but it wasn't necessarily recognized as such. So, and why was solitary confinement used? It has been used for various reasons, either in response as a disciplinary measure. It is sometimes used as a protective measure to protect the child from the rest of the group, as a health or sanitary measure, and that has happened quite frequently during the COVID pandemic, where children had been isolated because of the risk of infection in the group, or sometimes also for very de facto reason. For instance, if there was a shift change between the professional detention facility, or for other criteria. And what was very also widespread was a disregard in many occasions of procedural safeguards. So I wanted to give you just a few examples without going in depth into each of the examples, because you will have information in the paper. And out of the 7 countries, so we got 7 of our members across Europe. So I'm going to focus a little bit here on Europe to actually give us some information about what solitary confinement would look like, and if there actually were alternatives to solitary confinement. So we collected data from France, from Germany, from Austria, from Poland, from Italy, from Portugal. And we could actually notice that there were a very diversity of situation in 4 categories. First, the name, solitary confinement. It was really defined very differently in different countries. I'm giving you examples. In Germany, we speak about solitary confinement, segregation, room confinement. In Portugal, we speak about containment measures. In Poland, we speak about placement in an adaptation chamber. In Spain, we speak about separation from the group. In other countries, here I picked a bit from the other parts outside of Europe, we talked about secure housing. We speak about involuntary commitment or involuntary hospitalization. So you see that there is really a very widespread of names that are being used, which makes it even more difficult to grasp how solitary confinement is applied in practice. In terms of procedural safeguard, the second category that shows so much diversity, it was quite common to see that there was not always applied. Poland actually shared with us that the placement of children for serious crimes sometimes happens together with adults, so that the rules applied to adults apply to the child. In Germany, an example is that above 24 hours, a lawyer must be called, but in many other occasions, children are placed in solitary confinement without even informing a legal representative of the child. The third item that is really diverse that we have noticed was about the duration of the solitary confinement. There have not been some clear definition about is there a minimum or a maximum time for the duration of solitary confinement. And here we could have a range from, in France, it's mentioned, a maximum of 7 days. But saying that there are solitary confinement, but this child can still have access to educational facilities. It's not explained how in practice that should actually work. In Germany, because of Germany being a federal state, there are various durations that are actually being mentioned from one federal state to another. In Portugal, it's a maximum of 24 hours. In Poland, it is linked to the age. A child below 14 can be placed in solitary confinement for up to 12 hours. Above 14, it can be up to 48 hours. In Spain, we come, as in France, a period of 7 days. In Austria, there is, and I will not go because I know that there are some colleagues later that will speak about Austria, that there is a mention of a period of 1 week where the CPT, the Committee to Prevent Torture, is actually advising a maximum of 3 days. So we see that duration can go from a few hours to several days. This is in the context of Europe. Outside of Europe, it goes to much more than 7 days. In the justification for solitary confinement is also widespread. In Germany, for example, it can be to address an escape risk. It can be because of violent behavior. In Portugal, it can be because of precautionary reasons. In Italy, it is a sanitary or a disciplinary measure or a protective measure. So when we looked at all of this, we wanted to make a proposition, and this is the strong message of our paper. It's about urging government to end solitary confinement, to find the solution, which is to implement alternatives which are non-violent and that are respectful of child rights. There must be core components that are core elements that are applied to the treatment of children in detention, as we have just heard from also Ton Liefaard. Any child that is, we don't want to see children deprived of liberty, and if there are any measure of isolation that would be considered, it should be in line with child justice principles. Facilities, resources should be adapted, but we don't want to see any form of isolation of children, because there are some countries that found maybe not solitary confinement, but another form of isolation that would have a very negative impact on the child in terms of psychosocial development, and they haven't shown actually positive results. Dignity of the child must be respected, and of course, very strict respect of procedural safeguard, for instance, notification of judges, of the lawyer, the implementation of clear complaint mechanism, the availability of this complaint mechanism, and also, of course, access to education and health, and also respect of all children's rights in the time that the child is deprived of liberty. So when we ask about various alternatives, it was very difficult to actually get feedback on what exact alternative exists, because detention facility didn't really consider other options than this isolation. But we got a bit of a glimpse from 2 countries. In Portugal, there was an example given from a crisis intervention manual that would be applied in the case of precautionary isolation, so that the sequence of intervention will take place from an open space interview to actually a space for timeout that would actually be preventive before even considering the complete isolation of the child. In Italy, and I will go in detail about that because we have a presentation later, it's about restorative justice as a measure to be used with children that involve volunteering and also workshops on emotions. So out of this, we actually had 8 recommendations that we want to support. First is to end the practice of solitary confinement by any name. We have heard there was different ways to define solitary confinement, but to really move from a punitive approach to an educational approach, is in particular because we are talking about children that actually have, particular needs. We want consistency in terminology and in definitions. Second, the recommendation is to adopt alternative to isolation, because research has shown that the fact, if we manage to diminish the punitive approaches, we actually increase the sense of safety and of security. If we diminish the isolation, it also has contributed in some cases to diminish the level of violence that there is among the peers in the institution. We want, of course, to have better investment in programs of prevention of tension between peers, but also between the young people and the detention facility staff, to address what are the root causes of detention, to have really a proactive approach, and to have a series of measures put in place, such as de-escalation techniques, incentive programs, early intervention programs, peer support groups, individual assessment, to really understand how to approach the matter if an isolation is being considered, to be able to prevent as much as possible to reach to that decision. 4, training of staff, of detention staff, in particular on soft skill and also on trauma-informed practice. 5, the meaningful inclusion of children opinions. I believe that we never say it enough. We need to hear the views and opinions of children and understand what actually children need and how the detention facility staff can really take into consideration their needs. and their vulnerability and their particular situations. 6, we want to guarantee the implementation of the procedural safeguard. It is not acceptable to have children in detention and their safeguards, those procedural safeguards, are not respected, and this should be part of short-term and long-term plans. 7, we need data collection, and this data needs to be disseminated. It has been extremely difficult to collect some data, so there needs to be better collaboration also between the public authority and the civil society organization to be able to collect more data and evidence, and to better understand the needs of certain groups such as LGBT groups, the children with mental health disabilities or with neurodisabilities, and other groups from ethnic minorities that might have particular needs and situations that needs to be addressed, and the situation must be monitored. So regular and really often monitoring of the situation of children in detention must be ensured. And last but not least, to identify the challenges that children face when they have to be placed in adult facilities, which should not take place, but as we know, this is a reality today. So these are actually some of the few words that I wanted to share with you in the response to this question of how we can apply child-friendly justice in the context of the prevention of solitary confinement. So thank you for your attention.
Mariama, thank to you for moving us to this child-centered dynamic and children's rights approach to solitary confinement, and so this specific practice that despite, I would say, the evolution and the discussion on children's rights centrality, even in this field, still perceive it, as you were saying, a measures that is valuable and for whatever reasons, disciplinary, protective, or for health-related reasons, but for which there is no evaluation, I would say, of what is in the interest of the child and where the respect of the rights of the child that is confronted with are lying. I'm sure we'll go back to this to these components in hopefully the Q&A question. I move to our third keynote. Thanks a lot. Helmut Sax, senior researcher at Ludwig Boltzmann Institute of Fundamental and Human Rights, my partner in the hosting of this webinar. Helmut works in the field of children's rights since more than 25 years. He was part of the international research team for the UN Global Studies on children deprived of liberty in 2019, conducting a follow-up project on deprivation of liberty of children in Austria, published earlier this year. Helmut, I'll pass the microphone to you for a discussion on disciplinary sanction. Thanks.
Thanks a lot, Roberta, and good morning and hello to everyone. I will also now try to actually share my screen. I hope you can see it right now. Yeah, thank you for the invitation to CREAN to join you in this seminar, and thank you to all the colleagues who also followed us in the preparation of this event. And it's truly a pleasure to see many of you again since those times, actually coming from the global study development process. As you hopefully can see, it's not a coincidence probably that I also choose to start with the UN Global Study the same way as Ton has done, because he was also a key member of our research team, like other colleagues present here in this webinar. Thanks also for mentioning the Boltzmann Institute, and yeah, we had an important role in that process, not least because of our former director, who actually was a co-founder of our institute, Manfred Nowak, and because yeah, the Boltzmann Institute as such is also the largest human rights institution we have in Austria. We are some 30 plus staff members here and dealing with all kinds of human rights issues, and children's rights is just one of them. But nevertheless, it was a huge opportunity for us when there was this possibility with the global study to participate in this process, as difficult as it was, organizational, technically speaking. Nevertheless, turning to our topic, perhaps just to highlight one particular aspect from all these discussions already at that time, that actually one of the conclusions from the global study was that detention of children, deprivation of liberty is a form of structural violence, because as diverse all these different settings have been in the administration of justice, in the migration context, in the situation of psychiatric children in psychiatric institutions, situation of children with disabilities. Nevertheless, a common aspect has always been it's some form of institutional placement, institutional care to some extent. And there should be some common principles based on a child rights-based approach. And nevertheless, as the reality check has shown, many of these principles and rights of children are constantly violated. And also what has been shown by the study, that we are actually speaking of millions of children. I put here some statistics, at least that kind of data we were able to bring together during this process. As far as administration of justice is concerned, we were speaking of some 410,000 children being in forms of criminal detention across the globe. If you include police custody, estimates go to a further 1 million of children being affected. So this is not singular cases, it's really an endemic problem which needs to be addressed. And for the purpose of our discussion here, which is about disciplinary measures and sanctions, the global study also already had some key recommendations, focusing particularly on this aspect to prevent violence against children, especially in the context of detention. Also, the global study underlined the need to prohibit solitary confinement of children, as Mariama has just explained why it's necessary, essential to move towards this goal. And at the same time, something which has been mentioned already also by Ton, discrimination is a big issue, especially when it comes to detention. There are certain special protection needs for children at risk of violence, but actually the problem starts earlier. There are certain groups of children at heightened risk of being put into detention, as we have discussed before, and also in the context of the global study. Just to give a bit of an overview, well, I'm not going into details of all these standards. One key message coming from that is actually that all the major also soft law standards, which are not based on conventions or which are not conventions as such, also address to some extent the question of disciplinary measures, including solitary confinement. This is just a list we already had included in the global study. Actually, colleagues of mine, they prepared a even longer, more detailed list. But yeah, I would just like to highlight some basic elements out of that, because the basic focus of this webinar is on disciplinary measures. So how to maintain good order, so to say, discipline, while being in detention in the context of children, and which is a practical challenge from many different perspectives. This is just an overview. I just added some of the more regional, the European standards, especially around the CPT, and also in the context of the Council of Europe, the European rules for juvenile offenders subject to sanctions or measures. And I will use them basically as an example now to contextualize this whole topic. Like you can see here from this table of contents of the European rules, we are speaking of disciplinary measures, sanctions in the context of part 3, which is about situation and how you deal with the situation in deprivation of liberty, which deals with all kinds of aspects, how to admit someone to such a facility, the way how you are treated, access to all kinds of services. And then there is this one part on E13, how to maintain good order. So that's how you basically deal with conflicts, for example, happening while children are detained in such institutions. And one subsection then actually deals with discipline and punishment. And already from that title, you can see that maintaining discipline is kind of framed in a punitive context, in the context of punishment, which actually leads to some tensions, because even the rules as such already state in the beginning, first of all, disciplinary measures should be a measure of last resort. But at the same time, actually there should be an aim for educational interaction, and that is already emphasized previously in these rules and in many of these other international documents, that actually detention of juveniles in order to limit further harm should follow an educational approach with this nice goal in the end to help reintegration into society and further promote this, so that those young people actually can further develop as members of society and good citizens, so to say, stopping getting into conflict with the law, so to say, which is a nice goal. But as we have already heard before, actually, detention has many negative impacts, and this is an underlying tension of this whole context, and it is kind of repeated in the context of how you deal with conflicts while in detention, how you actually aim to maintain discipline. One aspect I wanted to mention here specifically also, because this might be this will be actually also a focus of the following country case studies, that there are also key principles what should be done at the national level. First of all, that law clearly determines what kind of acts or omissions constitute disciplinary offenses, and not only like a catalog of measures and sanctions, but also what kind of procedures are there to follow, including due process, that you have competent authorities to impose these measures, and that there's a review mechanism included, including some further standards like that juveniles are actually informed of what has been brought against them, and that they are able to effectively defend themselves. Actually, solitary confinement is the kind of worst case scenario, if you want. So it's about detention inside detention, and clearly this is also addressed in all of these rules. The European rules prohibit the use of collective punishment, the use of corporal punishment, beating of children, clearly placement in dark cells and other degrading forms of punishment. And actually solitary confinement should not be imposed on juveniles. And there are some further provisions and restrictions not to infringe further on basic children's rights, like also to highlight that access to family contacts and visits should not be restricted for disciplinary measures. Basically, this has been confirmed more recently also from the CSC Committee General Comment number 24. I just took out some excerpts here from the section on treatment and conditions while children are actually detained. Above all, to respect inherent dignity of the child and fundamental objectives of institutional care, which again highlights this aspect of, in all of these settings, we're actually talking about institutional care types and linked to some form of a closed institution, which has some particular implications for protection of the rights of children and actually creating some challenges. At the same time, just as a side comment, when we have been working like on the global study and also on our follow-up project, I think it would be worth to reflect also on the situation of children outside of institutional care and what kind of principles are applied there, and thinking of the situation of parents and what kind of educational means are acceptable and justifiable also from a parental education point of view. But nevertheless, just because also in order of keeping with the time, just to mention that, also the CSC committee emphasized the need to find alternatives to all kinds of corporal punishment and further deprivation of basic children's rights, and clearly stated solitary confinement should not be used for a child. As Mariama has explained before, this is not an area where there is not some controversy about that. Also the standards not fully consistent, harmonized as it has, and also in terms of practice, as we have heard from Mariama. I already mentioned here also the position paper to underline this. So it's not only about terminology and purposes and justifications. Actually, there's a divergence of some standards, like CPT basically also says, well, to a certain extent, 3 days would be a maximum, while there is now this strong movement to actually conclude that solitary confinement should never be used for a child in terms of a form of punitive isolation, so to say, because of all these negative impacts. And also the CSC committee underlines the need to have some mechanisms for review, for redress, to complain about such practices, that children should know their rights, and that there should be external monitoring of these sites. So this is already my final slides, which I would like to use for some concluding observations, so to say. I think it is imperative to consider this dual strategy approach, which comes with a child rights-based approach, which is, on the one hand, you have the rights holders, you have children in this context, and you have the duty bearers, like state administration, dealing with detention facilities. And from a child rights perspective, you have to work and build capacities with both sides. And so far, we have been talking a lot already about the accountability of duty bearers, and to have a clear legal framework, for example, inside detention, to have strong capacities and skills and qualified trainings. One observation I would like to make at this point is that all these standards actually focus rather on the negative side only. So what is prohibited in terms of disciplinary measures, but those standards do not give that much insight when it comes to the positive approach. So what should be actually done? And again, this reminds me of some discussions in the more private context of, or like families. We have provisions against any form of violence, domestic violence, when it comes to positive parenting, yeah, it's often less clear in many discussions and policy papers what is actually meant here. And perhaps also in that context of detention facilities, I think it would be worthwhile to have some further attention to what would be like positive caring concepts and educational approach on an operational level when we speak of alternatives to punitive disciplinary sanctions. And also in this regard, I very much appreciate the paper published by Claire Desom and the Disciplinary Justice Network and partners, which actually has this very interesting section on alternatives, as Mariama has already just presented, which gives some much clearer picture of what do we say. On the one hand, we prohibit this or that practice, but then we need to offer also practitioners positive examples how to protect children's rights from that perspective. And at the same time, just to finish on that, the empowerment of children, which I think is an essential component. First, that there's transparency and that those in detention know about the rules, the house rules, whatever is expected from them in the context of avoiding conflict or dealing with conflicts, and also which is based on some experiences we made at the Boltzmann Institute for our previous research studies. Some 10 years ago, I was involved in one which was addressing violence inside detention. And for example, where communication problems were highlighted by the kids as one typical example, where there can be misunderstandings, some restrictions because there have been staff shortages, which then quickly escalated into some conflicts, and which could have been avoided by just simply explaining to those inmates why there were a necessity for such a restriction, and that it was only temporary, and etc. And one of the discussions we already had at that time, and also which we made as a recommendation in the Austrian follow-up study to the global study, is to establish inmate spokesperson systems, so to say, so to have a person like in the context of a company, to have some workers' council, so to have inmates who actually represent the interests of young people inside those facilities, and which then would have the possibility to engage with the superiors in addressing some problems, which might also help maintain good order and avoid further escalation of conflicts. So that concludes my presentation, and thank you for your attention.
Thank you, Helmut, for I would say adding another important layer to the discussion about the disciplinary sanction, and for concluding on these two components of accountability of the duty bearers and the referral system more at large in developing and implementing national policy and intervention pertaining these fields, but also for underlining this overlook of the empowerment components by putting into practice child detention measures. An attitude that I would say is evident that signs the failure of the juvenile justice system to meet probably core objectives that should be supporting and empowering, should be educational, should be meant to reintegrate and provide those children with the needed tools. I look to my, thanks Helmut, and I'll check what is my partner in moderation of this session, Hauke. Do we have question?
Yes, we have a question in the Q&A section, and I might just read it out quickly. So thank you from Ireland for the question. It's mentioned that you have practiced as barrister in the Children's Court and also in the child protection, and you're asking for your question related to mental health and disciplinary measures, given the prevalence of mental health problems among children in detention and the experiences of trauma and violence and addiction to high proportion of children in detention, to what extent is this considered in disciplinary measures in detention, and what research is the panel aware of undertaken in this regard? Does someone want to answer to this question from the experts?
Ton, would you like to?
Yeah, I can start. Maybe this is a very important question because of the reality, indeed, that there's so many children, young people with mental health issues in one or the other form of detention. Imposing a disciplinary regime on these children is often not really recognizing the actual needs from these children. So they act out, or they have intrinsic issues as a consequence of the mental health state they are in. And we know from research that that is a big group. And then we respond to that in a disciplinary way, which is basically imposing them a form of violence, or now how you define it doesn't really matter. You're placed in isolation while you're actually in need of care. So in the mental health sector, they use this as well. And one of the challenges there is, okay, what is the alternative for that kind of response to a child's behavior as a result of his mental health state? And in that whole domain, there's quite a big discussion now about the prevention of solitary confinement, so even the abolition of it. But of course, the alternative is often medication. And that is also extremely tricky. So you have to discuss, not only in your discussion and consideration, you should not only focus on solitary confinement and the abolition of it, but also you have to take into account the potential negative impact of medication. But there are more and more examples, and also research driven from the Netherlands, but I'm sure also in Ireland, but I'm not entirely sure. Maybe Ursula Kilkelly can say a bit more about that later on, that really capture this particular dynamic, because also in that domain there is something happening.
Thanks, Ton. I see that Helmut raises his hand. Helmut, please.
Well, yeah, just a quick additional comment, because that's something we also realized when we did this follow-up study in Austria on deprivation of liberty of children. Because on the one hand, there's an intersection between the criminal justice system and how it deals with children with mental health issues. And then there is this whole area of psychiatric care, which also contains a situation of deprivation of liberty quite clearly, and where there is not at all that much attention being paid to children as it should be. Like in Austria, we had situations that children, because of lack of capacity, specifically for facilities for children, that children have been placed with adult institutions in psychiatric care with all these follow-up problems, and which also is not respecting some fundamental principles like separation from adults, even if the situation is different in a psychiatric care institution. But nevertheless, in terms of qualification of staff, it makes a huge difference if you work with children, and this can be with very small children below some ages of criminal responsibilities, because this does not apply to that context. Depression can happen earlier than some of these age limits. So and actually in Austria, only last year we had an amendment to the legislation which covers psychiatric care, that specific principles addressing the situation of children were included. Before, there were just some generic provisions included with no specific attention to children. And we still have a huge problem not having enough psychiatrists, specifically for children and young people. So I definitely think this is a key area which should get some further attention. Thank you.
Thanks, Helmut. I think there were other, I believe there were, let me check, yes. Other answers were already, sorry, other questions were already answered in the chat. I wanted to thank you, my panelists, Mariama, Ton, and Helmut, for your inspiring keynote speeches. And we'll break for 5 minutes. Am I correct?
Yes, we have a break for 5 minutes because before we continue with the national disciplinary sanction regimes. And I see there is a follow-up question from Ireland. Maybe we have later the time, because for the national discussion, we have a Q&A section after each presentation. So Ursula might be able to address this question later.
Yeah, the one.
Thank you.
Yeah. Thanks to all of you. Bye. Have a great
My pleasure. Thank you.
So welcome back after the very short coffee break on this Friday midday. And first of all, I would like to thank the speakers of the first part of the webinar today, namely Ton Liefaard, Mariama Diallo, and Helmut Sax, for their excellent presentations. And thank you, Roberta, also for the great moderation of the first part of today's webinar. My name is Hauke Benjes-Pitcz, and I'm a child rights researcher and project coordinator at the LBI-GMR, so the Ludwig Boltzmann Institute of Fundamental Human Rights. And it's a pleasure to moderate the second part of the webinar on disciplinary sanctions today. After the very insightful keynotes and the contextualization of the disciplinary sanctions system globally and its legal framework, we will now focus in section 2 on 3 disciplinary sanction regimes in use detention facilities on the national level, namely in Austria, Ireland, and Italy. And having said that, I would like to shortly refer to the limitations of today's webinar. First of all, we are not able to reflect on all perspectives that are relevant when discussing disciplinary sanctions. For instance, the perspective of a psychological expert, as this question has been raised by a lawyer from Ireland. And second of all, we have a rather Western European focus and do apologize for not being able to reflect on the disciplinary sanction regulations in Central or Eastern Europe today. This may be explained by the time constraints we face, but also by the relevance of the topic in each of the selected countries, as in all of the 3 countries of the expert we will listen to now, sanction regimes are being contested or were to some extent recently under reform to meet contemporary dynamics within the youth justice system. After each presentation, we will have a short Q&A round. So this below you can answer again or type in your question, and you can post your question anytime in the section. I will try to address them afterwards when discussing with the expert after the presentation. Thank you also to our colleagues Mane and Charlotte, who are having a constant eye on the Q&A section and managing the webinar in the background from the technical perspectives. I would now like to turn to our expert who will present on Austria's disciplinary sanction regime, Magister Manuela Albl from the Austrian Ombudsman Board. The AOB is monitoring the public administration in Austria since 1977 and holds a mandate as Austria's national preventive mechanism based on the OPCAT and the CRPD since 2012. Moreover, the AOB has recently gained the A status as NHRI, being in compliance with the Paris Principles. One of the 3 ombudsman persons is Gabi Schwarz, and Ms. Albl is working with her. Ms. Albl herself is working as a legal expert at the AOB since 2010, and she's responsible for individual complaints of inmates concerning maladministration, as well as NPM visits, including filing reports and recommendations. She was recently responsible for the preparation of the report Youth in Detention, published by the AOB in 2022, and that is why we are very happy that she is joining us today. Thank you, Ms. Albl. The floor is yours.
A pleasure, thank you. So I'd like to share my presentation. One moment. I hope you can see it now.
Yes, we can see it.
Okay, thank you. Hello and welcome to my presentation on our special report, Youth in Detention. Today I will focus on our perceptions regarding disciplinary measures. Before I get to the actual topic of the presentation, I would like to share some general information about the Austrian Ombudsman Board, the juvenile detention in Austria, and briefly explain how disciplinary measures are regulated. The Austrian Ombudsman Board is an independent supervisory body. It investigates either individual complaints lodged by citizens or ex officio the work of the administration. The administration of justice is part of the administration. It includes the penal system. In 2012, the Austrian Ombudsman Board has been entrusted for the protection and promotion of human rights to monitor, together with 7 commissions, institutions in which deprivation or restriction of personal freedom occurs or can occur, such as in prisons. The legal constitutional mandate for protecting human rights as a national prevention mechanism is based on 2 significant legal bases of the United Nations. The first one is the UN Optional Protocol to the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, OPCAT. And the second one is the UN Convention on the Rights of Persons with Disabilities. The Ombudsman Board regularly reports to the National and the Federal Council on its perceptions. And in the fall of 2022, we published a report on youth in detention. Although juveniles come of age at 18, in Austria young people are in juvenile detention until they turn 21. Persons who have reached the age of 18 but not 21 are called young adults. At the time of reporting in August 2022, 450 of them were in detention. 113 were younger than 18 and 337 were young adults. For ease of understanding, I will use for both groups of detainees only the term juveniles in my presentation. In Austria, there is only one special institution for male juveniles who were sentenced to longer prison terms. Shorter prison terms they spend in prisons for pre-trial detainees, which often have separate departments for juveniles. Unfortunately, however, not all prisons have special units for juveniles. Female prisoners spend their time either in the only women's prison called Schwarzau or in special departments. The Penitentiary System Act sanctions irregular or bad behavior by inmates. The purpose of these provisions is to ensure order in the prison system. The unpleasant behaviors are standardized in sections 107 of the Penitentiary System Act. For example, these offenses include escape, unauthorized contact with other persons, unauthorized possession of objects, immoral behavior, refusal to work, pollution or damage to prison property. Whenever an inmate does not behave properly, the direct supervising officer shall warn him. In case of minor guilt, and if the violation has no or only insignificant consequences, it is no necessary to punish an inmate. In this case, the inmate is only to be warned. This warning is not a disciplinary sanction and has no consequences. If a warning doesn't seem to be enough, or if there is a suspicion of a criminal offense, the directly supervising staff member must report this to the head of the institution. Then the case may be dismissed, for example, because no guilt could be proven or the act was not an offense to be punished. The inmate can be left with a warning, or in case of a confession or clear facts, a shortened procedure can be carried out. The only possible punishment then is a reprimand or a fine. If the facts of the case are not clear, or if there is an appeal against the sentence, the head of the institution must initiate proceedings. The purpose of these proceedings is to establish the relevant facts of the case. The inmate may comment on the incident. The head of the institution can end the proceedings at any time. He can also leave it with the already issued warning, or he can also impose a penalty. The penalty must be pronounced in form of a decision, and against this decision, the inmate can file an appeal. The following penalties are possible according to the Penitentiary System Act. There is a reprimand, a cancellation or limitation of benefits, the rights to dispose of the money, the television, correspondence, visitation, or telephone calls can be restricted, a fine, or a solitary confinement. There is also the strict solitary confinement. It means that in addition to solitary confinement, there is either a restriction on the time the lights are on in the detention room, or no opportunity to work as long as the sentence lasts. Solitary confinement for up to 4 weeks for adults and for up to 1 week for juveniles is the most severe disciplinary sanction that may be imposed on prisoners in Austria. When an inmate is in solitary confinement, he must also be separated from other inmates during daily outdoor exercises, and he may only carry out work in the cell. Solitary confinement can have harmful effects, so the isolated person needs increased care. A juvenile inmate is allowed to talk to someone twice a day. For the report of the Austrian Ombudsman Board published in 2022, the commissions made 12 visits to correctional institutions with this focus starting in the summer of 2020. In addition, the Austrian Ombudsman Board visited 15 prisons to offer counseling sessions to detainees and staff. All aspects of the situation of juveniles in detention were monitored and reviewed. Among other things, we examined the accommodation, opening times of the cells, training and employment opportunities, support and medical care. In the following, I will briefly outline the perceptions relating to disciplinary measures. Back in June 2019, the Austrian Ombudsman Board criticized the punishment of breaches of the rules in juvenile department in Austria's largest prison, Vienna Josefstadt. The prison guards set the consequences for breaches on a case-by-case basis. There is thus no clear definition of which punishment is imposed to what extent for which breach. This practice is contrary to the international recommendations according to which any type of behavior that constitutes a breach of discipline shall be described as a statement of facts and the sanctions defined amongst others. So the United Nations rules for the protection of juveniles deprived of the library, chapter L, I think. All disciplinary actions should also be documented. The Austrian Ombudsman Board also believes that the punishment with disciplinary measures can lead to inhuman or degrading treatment if the consequences of misconduct are not clearly defined in advance. In order to ensure a uniform penalty practice, we have recommended a creation of a catalogue with criteria or guidelines for comparable violations with harmonized disciplinary sanctions or measures. During a visit to Grazia Comini Correctional Institution in summer 2020, our commission also found that there are no clearly defined disciplinary measures against violations, such as the smoking ban in the juvenile department. The inmates stated that the prison guards sanction irregular behavior in very different ways. The Federal Ministry of Justice responded to the criticism and summarized the rules of conduct, but without penalties, in a poster that is now on display in the department. A pilot project took place at the Vienna Josefstadt Correctional Institution in 2021. Not every breach of the rules in the juvenile department ends with a disciplinary sanction, but alternative measures such as warnings, reparation, or dealing with the incident in question should be used first. Possible measures include to ban television or not allowing him to take part in joint activities for a couple of days. The juveniles should be directly involved in the process and thus learn to take responsibility. These measures are called pedagogical measures. An evaluation of this project should take place in the fall of 2022. I will report on the outcome of this project later. The report also criticized the solitary confinement of juveniles. The Austrian Ombudsman Board found that a juvenile was sentenced to strict solitary confinement twice within 13 months. As already mentioned, strict solitary confinement means that in addition to solitary confinement, there is either a restriction on the time the lights are on in the detention room, or no opportunity to work as long as the imprisonment lasts. The first strict solitary confinement was imposed on the then 14-year-old boy shortly after his imprisonment for insulting prison guards. The decision only included aggravating circumstances. It did not mention any mitigating circumstances. The Austrian Ombudsman Board doubted whether a week of strict solitary confinement was necessary and proportionate due to an insult. Due to a brawl, another strict solitary confinement was imposed for 14 days, although there is a maximum limit of 1 week for juveniles. The Austrian Ombudsman Board criticized the type and the length of the sentence in this case. The principle of proportionality must always be observed when imposing solitary confinement. The Austrian Ombudsman Board recommends adapting the national law to the international recommendations and standards. The CPT has repeatedly stated that the maximum period of solitary confinement as a punishment for adult prisoners should not exceed 14 days for a given offense, probably less. Further, given their particular vulnerability, solitary confinement should never be imposed on juveniles, as set out in Rule 60.6a of the reversed European prison rules. The Federal Ministry of Justice agreed with this criticism in the specific case and promised to take the recommendations of the Austrian Ombudsman Board into account in further decisions. But it is not yet clear whether the law will be also amended so that solitary confinement for juveniles will no longer be possible. So what happened since the report? The Federal Ministry of Justice has meanwhile refused to develop a catalogue of criteria or guidelines for comparable violations with harmonized disciplinary sanctions. They prefer to make decisions on a case-by-case basis because this allows considering individual aspects. The pedagogical pilot project mentioned earlier has now been completed. It turned out that staff members who do not normally work in the juvenile department made almost half of all the reports of offenses. Due to a lack of appropriate training, they could not carry out any pedagogical measures. This fact led to the decision to train an additional group of prison guards with the concept of pedagogical measures so that they can then work regularly in the juvenile department. But due to a massive resistance from prison guards, this measure could not be implemented after all. We are not satisfied with this answer, but we cannot force the ministry. At the end of the project, the juveniles got a feedback sheet on the pedagogical measures. They stated that they felt the measures were appropriate and fair. The Federal Ministry of Justice also considers pedagogical measures to be a good additional option. They can expand the educational component of juvenile detention and improve the behavior of juveniles. All prisons are now instructed to give preference to pedagogical measures for juveniles in the case of misdemeanors, if possible and appropriate. In preparation for this event, the Austrian Ombudsman Board once again asked the Federal Ministry of Justice how often solitary confinement of juveniles occurs. Juveniles were sentenced to solitary confinement 16 times last year, between September 2022 and October 2023. This frequency surprised the Austrian Ombudsman Board. Half of the sentences were suspended on probation. One sentence was not executed because the inmate escaped from the institution. The solitary confinement of the other sentences lasted between 1 and 5 days. The Austrian Ombudsman Board will repeat its recommendation not to impose solitary confinement on juveniles. So, to summarize, I would like to mention the Austrian Ombudsman Board's recommendation once again. Given to their particular vulnerability, solitary confinement should never be imposed on juveniles. The principle of proportionality must be observed when imposing solitary confinement. There should be clearly defined rules, and juveniles in particular need to know what punishment they can expect for what misconduct. All disciplinary actions should be documented, and pedagogical measures are a good additional option for juveniles. And the staff who look after juveniles in detention must be specially trained. So thank you for your attention. I stopped.
Thank you very much,
yeah.
Ms. Albl, and thank you especially for even requesting updated information from the ministry. We really appreciate that. I would like the audience to address any question you might have to Ms. Albl from the Austrian Ombudsman Board, also NPM of Austria. You can write it now in the Q&A section. And if as there are no questions at the moment, I would like to use this opportunity to address some questions from my side. Ms. Albl, you have mentioned that Section 107 of the Penitentiary System Act defines which behavior or rule breaking may lead to disciplinary sanctions. Do you have an overview for which reasons disciplinary sanctions are most often applied? And are the pedagogical measures an adequate alternative to disciplinary sanctions for all types of challenging behavior listed in paragraph 107?
Yeah, thank you for this question. I don't have detailed information on the juveniles' misdemeanors for disciplinary sanctions. But I can say that many offenses have to do with the smoking ban for juveniles. They secretly obtain cigarettes or trade them. In my experience, many of the juvenile detainees have been smoking for years and find it difficult to accept that smoking in prison is not permitted for inmates under the age of 18. Of course, pedagogical measures are not always the right choice. They should, above all, be a supplement to the usual disciplinary sanctions. I believe that it makes more sense, especially for juveniles, if they damage something in prison, for example, that they repair the damaged property than paying a fine. I'd like to add that I received more information about pedagogical measures yesterday. I got the decree, and the decree informing the prisons about these measures underlines, among other things, how important it is to talk to the inmates after an offense. The head of the correctional institutions may also define suitable measures other than those specified in the decree. The decree includes, for example, a ban on television, cleaning the detention room or windows, repairing the equipment in the detention room, and so on. All these measures must be documented, including the conversations, what's very important, I think. And it's also recommended to motivate the juveniles and offer them incentives so that they stick to the rules. For example, more sports or the use of a game console, or juveniles should also be able to use the leisure room beyond the usual permitted times. So overall, I think the use of pedagogical measures as a supplement to disciplinary sanctions make a lot of sense for juveniles.
Thank you, Ms. Albl. And at this moment, I might need to ask our next speaker, Ursula Kilkelly, for some delay of 5-10 minutes, because I hope you're fine with that. Perfect. Because we still have actually some interesting questions from the expert and the audience. And I would start with a question by one of our experts today. The question was raised: do children and young people in a detention have the possibility to directly get in touch with the Ombudsperson office or any other body or actor to report, for example, the use of solitary confinement or another sanctuary measure that they perceive as a violation of their rights? And in connection to that, do they think they are adequately informed about these and other rights they're entitled to in detention?
Yes, I think they are informed, and it occurs very often that the juveniles write us. We go to the prisons and offer time to speak to them, and they are. I think all inmates in Austria are informed about the Austrian Ombudsman Board and their possibilities.
Thank you, and I hope this question was answered with that. And then we have a question from our participants. We have a very active participant, I think from Egypt, and the lawyer there has raised the question, may I ask you about the age of criminal responsibility for children in Austria? I think it's 14. And what are the procedures followed if a child commits a crime while he or she is under the legal age for criminal responsibility? And what about children who commit crimes who do not have a home? So basically asking what happens to children who are 13 years old or 12 years old who commit a crime. And maybe, Helmut, you might also be able to jump in and ask there and add to this question.
Yeah, but I cannot say that's no problem of the prison, because in Austria prison or juveniles are in prison between 14 and after they got 14 and not before. What happened before? That's a question I can't answer exactly. Sorry.
Yeah, I think it's a probably child protection institution.
Yeah.
The Kinder- und Jugendanwalt, the Kinder- und Jugendhilfe might take over them. So I'm not sure if Helmut is currently online. I know you have, you know what the procedure, so maybe you would like to add to these questions.
Well, perhaps just to mention, as you have already outlined, and thanks for the question, but at least ideally there should be a complementary mechanism for those below the age of criminal responsibility, that the child protection system, the child welfare system actually takes over in such situations. So if they are not criminally responsible, then it's basically the parents who have the main responsibility, and yeah, kids will be brought back to those parents, or if they are based in institutional care, then to the staff of this institution, and then it is left basically to them to decide on what kind of consequences will follow. And there, of course, there might be some liability issues if damages have happened. Still, it would be the responsibility then for the parents to take this into account. At least that's the theory. The practice problem is, at least in Austria, that this is a big challenge, since this intersection between the general child protection system and the justice system is not working perfectly well together, because of lack of capacities, especially with the general child protection system, that there are not enough possibilities to work with those families where there are conflicts, dysfunctional family situations. And sometimes the consequence is just that, the justice system kind of waits until they reach the age of criminal responsibility, and then they will be basically being sent to detention. Because it was not possible to prevent this in the first hand, because of, from my perspective, there would be much more possibility to first prevent children or young people getting in conflict with the law if there would be earlier intervention capacities for the child protection system, because as we have discussed before, the overall priority should be to avoid children getting into the contact with justice system, especially avoid getting into detention. So that's this question of interface and complementarity of approaches is really an issue in Austria.
Yes, and thanks for the question, because it's very relevant, and also from the German context, we had most recently, I think, a murder case of 12-year-old girls who murdered a classmate, and there is always this public outcry to actually lower the minimum age of criminal responsibility, which is definitely not something which would solve this problem or is any child-friendly approach. But yeah, we have the same in Austria also here, that then there is a lot of newspaper articles, police or other actors giving interviews to lower the age. So this is a big challenge, I think. So thank you both for answering the question. I see there are no more questions. So with that, I would like to thank you, Ms. Albl, once more for your interesting presentation and the insight into the Austrian disciplinary sanction system, and would now like to welcome our expert from Ireland, Ursula Kilkelly. She is a professor of law with an established profile in international children's rights and youth justice at the University College Cork. The UCC is also an active member of the CREAN network, who hosted last year's Children's Rights Research Symposium. Ursula is also the Vice President of Global Engagement at UCC, and she has lectured on children's rights and youth justice for over 20 years, published several monographs, edited collections, and nearly 100 articles and book chapters in this area. And I could probably go on and on with a long list of her achievements, but would like to focus now on the most relevant one regarding the topic today. And that is that she was a chairperson of the Obersttown Children Detention Campus until beginning of this year, overseeing a major change project to embed best practice and children's rights into Ireland's national detention facility. This work is documented in one of her most recent books, Advancing Children's Rights in Detention. My colleagues will also post a link to the book now in the chat, and she will provide us with some interesting insights from this project and book regarding the management of challenging behavior. Thank you, Ursula, for joining us today.
Thank you very much. It's great to be here with you all, and thanks for the opportunity to speak to what is a really important issue in the context of youth detention, and on which I hope I can provide perhaps a slightly different perspective. As you said, Hauke, I've been somewhat of an insider in this process of youth detention for a number of years, 10 years in total. And what I hope to bring to you all at this session is a sense of how these issues look from that internal perspective. And I suppose some of what we have been discussing already this morning will no doubt come up, but what I would like you to come away with is, I suppose, the complexity of implementing recommendations and standards, which are, of course, entirely legitimate and hugely important. But I think the implementation of which requires a level of understanding from the internal point of view that I think is valuable and hopefully can be part of our discussion today. I'm hoping you can see my slides there.
Yes, we can see the slides.
Great. Okay. I'm just see if I can put them into slideshow. Okay. So, and I think the other point that I would make is with reference to the language of disciplinary sanction. And Mariama made the really important point that there is so many different terms and terminology used with regard to both disciplinary sanctions, but also solitary confinement. In the context of our youth facility, we describe and we use the term single separation. And I completely take the point that regardless of what you call it, there is a problematic element to it. But I think there's also a subtle difference between some forms of solitary confinement, which are ultimately punitive and always harmful, and seeing single separation or a mechanism or a procedure, a process like that as part of both behavior management, but also child development and support. To Roisin's point earlier about mental health, I think we can take it that every single one of the young people that we come across in this environment have mental health challenges and difficulties. Some, of course, are more acute than others, but there really is no scenario where any measure like this could or should be used without having explicit regard to the particular circumstances that the young person has, including the mental health challenges. So there is a spectrum, I think, of measures that we're discussing here. And I don't want it all to take away from the gravity of many of the practices that we see in detention all over the world. They are deeply problematic in many, many cases. But I do want to provide a slightly different perspective on how taking the children's rights standards into practice inside in an institution like ours in Obersttown can present, I think, a different way of approaching this issue. I think the point that I want to make here in the first instance is that this has been a process of very significant change, probably over 8 or 9 or 10 years in Ireland. Ireland is a very small jurisdiction with 5 million people, and with a very explicit ambition for rights-based youth justice, including law and policy that's really focused on child-centred detention for all under 18. So this, I think it's fair to say, this issue does not happen in a vacuum, and the change that's taken place cannot be separated out from the wider ambition at a national level to have a greater regard for children as children in the youth justice system. When we took over, and I'm referring to we in the context particularly of Pat Bergen and I, who was director at the time when I was chair for the most part, but also the wider community who was involved in this practice of change. We had children under 16 detained in very poor conditions, fragmented services, and we had children over 16 years in adult prison, and their conditions in St. Patrick's Institution in particular were even worse. And that's in a system where the age of criminal responsibility is 12. So we had segregated children depending on an arbitrary age of 16. What we see now through a process and a programme of reform and development is not only a better experience for children who are deprived of liberty, with regard to their care, education, their health, their work and offending behaviour, and their preparation for leaving, our KEHOP framework, which is based on our legislation there. We have a reduced number of children in detention. We'll talk about that in a second. And we have closed all the older facilities. So as part of this process of change within the facility that I'm going to talk about, we had a much wider system reform process underway, and the benefit to children in particular of closing the much maligned St. Patrick's Institution and creating the service and the facility that would support all under 18s, regardless of the offence, regardless of their circumstances, to receive a child-centred model of care in detention. That also came with €56 million of a new facility, a whole new approach to staff recruitment, training and support, and new leadership, and a very significant resourcing in a multidisciplinary way of the care provided. And on the top, you'll see the model which we developed as part of our book in really taking all the learning from Overstown against the backdrop of international children's rights standards and saying, these are the 5 P's, the 5 principles that we think are really important when you distill it down. The obvious ones of protection, and provision, but also participation, which I'll talk about, preparation in terms of preparation for leaving, and partnership, because this is not a process that can be done alone or in isolation, thus the jigsaw puzzle piece of all the other aspects of the system. And in particular with regard to what I'm going to talk about in a second in terms of the lowering of the rates of the use of single separation and a physical intervention in Overstown over the years. This has been a process of culture change, not just a change in practice, because that actually only takes you so far. And that's, I think, the second really important kind of message. So you will see here from this graph that our use of single separations back in 2016, before which we really had records you couldn't rely on. And even within this graph, I think you have to take that as read. These are difficult figures to pull together in a complex process. We had over 3,000 incidents of single separation, bringing that right back down to a more stable and consistent level from, if you like, from 2020 on to 2022. The orange box indicates the average daily population in Overstown over that period. So 42 in the years 16-17 being the average, and 32 being our average in 2022. And that's relevant, of course, to the rate of use of the practice, depending how many young people are there. I'm not going to say too much about physical interventions because it's a slightly different issue, and we can discuss it in questions, but I do think it's important to see here the some success in this area, but arguably less. And my view on that, or point on that, would probably be that this is a different type of practice. It has a different focus and purpose. Is much more about stabilizing the behavior of a young person, reducing the physical threat they pose to themselves and to others, and doing that in a safe manner as possible. And I'm happy to say a bit more about that, but I think it's also important to, I think, acknowledge that it has, and it is probably much more impacted by the complexity of need among the young people who are in detention at any one time. So spikes can be impacted by particularly challenging behavior by certain young people, and how that's managed. So it's a dynamic and complex picture, and I'll say a little bit more perhaps about that in the questions. So how did we reduce our numbers right back from 3,000 odd to in and around 600 instances of separation? And you'll know that within that I haven't made clear, haven't talked about, or don't have time to talk about the range of periods of time. But within that, you can take it that we have also, in addition to reducing the numbers, reduce the length of time. And that's been absolutely critical as part of the cultural shift, the cultural change. There are a number of mechanisms that on reflection have been really vital in terms of changing this practice. The first is the whole question of policy. So we, looking back on older policy, were less than clear about the purpose for which single separation was to be used. We framed it very deliberately in 2017-18 as a restrictive practice, making it clear that this was a restriction on the rights of young people. But single separation, physical intervention, and the use of handcuffs were all classified as restrictive practices. And that brought them into a different category of, if you like, of intervention, where the staff member had to be very mindful that any use of this practice brought with it a certain particular level of both of procedural safeguards and of requirements and obligations and duties on behalf of the staff. So it really helped to shift the mindset into what was perhaps a more go-to measure that had a vagueness about it into a much more precise one. The policy increasing over time as we refined the policy set out the clear circumstances in which it was permitted to use these practices, making clear that they were to be a measure of last resort and only where nothing else was effective in addressing the risk to either the welfare, the safety of the young person, or that of other either young people or staff. And really refining it so that it met those circumstances and that there was a clear understanding through staff training and development that this was the expectation. The other part of this, and one which has continued to be a challenge, has been the requirement to record all instances accurately, the reasons for those instances, the length of time, the continuing review and monitoring, and then separately the management review of all those practices. So we would at the most acute times have had really tight management review up to the level of director of all the use of single separation, to the point where there were daily check-ins on any individual who was in that category in separation, so that plans were progressing as soon as a separation was initiated to make sure the young person was out and back around in circulation. Our definition, it's worth saying, really does relate to the young person being separated from their peers. They are not put in an isolation room. They are not isolated from adults. They are separated from their peers until such time as they can be safely returned to the group, and that is clearly a real priority from the beginning of the period of separation. And that again is something that has continued to evolve in progressing the practice. The monitoring throughout these years was absolutely crucial. And so at board level, and I was chair, we had a very determined and visible focus on the monitoring of this practice. We communicated the expectations routinely to management and to staff about what we wanted to see, the numbers coming down, but also the length of time. And we interrogated every board meeting. We met monthly and in between in our other committees to really drive down the practice to make clear that that was the expectation and that we were receiving information and regularly reviewing that information to ensure that there was no complacency about the practice. And we also had throughout that time annual inspections from our national inspectorate, who also had a very relentless focus, not just on the use of separation, which they routinely called out because they did analysis of files, but also on the recording. So they routinely and continue to call out that recording of the detailed information involved is not sufficient to enable the kind of scrutiny that's required for a practice of this nature. The other really important element of changing practice over time has been the, again, very relentless, I think, and legitimate media and civil society scrutiny and that this practice was under for many years. We, I think it's fair to say, embraced that at appropriate times. Engaged with media about the practice, try to explain its purpose, its use, while also making our use of the practice available through data shared on the website. And you can see all of that data on the website, so which we could, but that information continues to be published quarterly. So those elements have been really important overall in the process of change. There was an unusual role played by litigation. And I think, again, as a process that shed and that shone a light on the use of separation at acute times, this was really important. Every young person in Oberstein has the right to judicially review their treatment, and many do. And single separation was a particular focus in the key years of change. In particular, in 2017, there was a major case in the Irish High Court where a number of young people who had spent long periods of time, days in single separation following a very serious period of disorder on the campus at a time of industrial dispute. A number of young people had occupied part of the facility, ended up burning down one of the units, older units at the time. So a hugely disruptive and dangerous situation, following which the young people involved were separated from their peers. And they, as they were entitled to, took their case to the High Court, claiming a breach of their constitutional rights. The case, which is well worth reading, ultimately decided that there had been a breach of the boys' constitutional rights with regard to the absence of procedural safeguards. And in particular, the judge called out the poor records that were maintained at the time, and the light touch review of the decisions that were being made on the unit floor at the time. I think it's fair to say that the judge took account of the ongoing threats that the young people were making towards staff and each other as they were separated, and the highly volatile and challenging nature of the environment, and the difficulty in practice in managing what were really really acute set of circumstances. Having said that, there were some really important messages in the judgment. At the time, we had it legally analysed to make sure that any lessons that were there for us had to be learned. And we took account of all of that in revising our policy with regard to enhancing oversight, really focusing in on the procedural safeguards. And particularly the message, I would say the most important message was that from the point that a young person is separated from their peers, there needs to be a continuous process to return them to the group, and obviously responding very proactively to their health needs, to their need for fresh air and time outside, neither of which had been provided in the SF case, and contact with family, with solicitors, and with education. So all of that was taken on board and has helped to shape the development of the practice. We had, I think it's fair to say, some level of indication in relation to all of that work in the M decision in 2020, where the court noted that much of what had happened, certainly the circumstances in SF, were not repeated, but also that the criticism that the court had made of management and the board had been addressed in the intervening period. So that was an important milestone in showing progress. And it all led to our adoption of new rules under the legislation and what is now described as the Children's Rights Policy Framework, which really brings all of that together. The final thing I want to just mention before I conclude is a piece that's not directly relevant, but actually is hugely important as part of the transition that has been underway in Oberstan, and that is the elevation of the voice and the role of young people in decision-making, participation of young people in decision-making. Following the adoption of a national strategy, we adopted a participation strategy for the facility, which envisaged both individual residential unit and campus level participation by young people in decisions about them. We appointed an advocacy officer who is their advocate and ambassador, who links in directly following all these instances. So when a young person is separated or experiences an intervention, the advocacy officer is there to make sure that is a process that they can respond to, feedback on, and they regularly do. And we see that coming through our national inspectors reports, that young people feel those processes are respectful. They don't like them, but they understand their necessity and know that they can have a say when both during and after that process. We have a board young people committee meeting directly with young people to talk about how they experience their rights, and they've been consulted on experiences of physical restraint and the search policy and review of complaints. We have a complaint system. They have access to the Ombudsman for Children directly, as well as other advocacy organisations. We've also involved them in the interview and the selection of senior management roles. And overall, I think this has led to an increased sense that the young people can claim their rights and a greater transparency at all levels about their experiences. And there's lots of other instances of that that I won't share, but which are really evidencing, I think, that this is a really substantial and substantive change. So in conclusion, as I mentioned at the outset, it's important that both the disciplinary practices and the regime that's in place is only one piece of the puzzle. We don't actually talk in Oberstan about discipline. We acknowledge these are young people developing, learning, finding their way under really, really challenging circumstances. Disciplinary mechanisms, when young people have had their liberty taken away, are limited in effect in any event. These young people often have very little to lose. So apart from its human rights challenges, these are not practices that work with young people who have very particular needs. The second point is that the use of all of these practices is frequently cultural. It's not something you can simply do on a given day by banning or stopping. It's a little like physical punishment of children in the home. You actually have got to replace it with something else. You've got to support and develop your staff to think about these things differently. And it requires really that multifaceted strategy that I've set out there: law and policy, leadership, really broader societal scrutiny and change and appreciation for the complexity of the work being done, and ultimately has to sit within a rights-based model of care for young people. So I'll finish it there and look forward to any questions that everyone has. Thank you.
Thank you very much, Ursula, for this very impressive presentation and giving us an insight to this cultural change behind bars in Ireland and this holistic approach. I would now open the floor for questions from the audience. And yeah, Ms. Webb is very active, I see. Thank you very much. I just check with. This is just a comment, maybe Ms. Webb, while we might address another question first. I would also wanted to ask you if you want me to readdress the question you asked earlier this morning. Maybe then there is another question from Egypt asking, is there criminal protection for children who are exploited in criminal acts? And can a child's right to be heard be used to determine punishment?
I'm not sure I understand the question.
Maybe Mr. Rai from Egypt, could you maybe extend the question, explain it a little bit further? In the meantime, then I would address a question I have prepared. You wrote in your book, Ursula, that in Oberstown, residential social care staff are trained and supported to anticipate and respond to managing behavior in line with the principles, practice, and use of management of actual and potential aggression methodology. And also, staff originally expressed concerns. You also wrote about this suitability issue and that this was addressed by a review process. And we already talked about the minimum age of criminal responsibility earlier, and that Ireland, you mentioned as well, has a minimum age of only 12 years, for which it was recently criticized also by the CRC committee and their concluding observation, and asked to raise the minimum age to 14 years. So would you mind explaining maybe the differences when dealing with challenging behavior of a 12-year-old compared to 17-year-old, and why it was necessary to actually review this, this strategy?
Yeah, thanks. I mean, that it relates to the fact that that Oberstown had and its associate schools had responsibility for under 16s only up until, well, it started to change in 2012 when we took responsibility for 16-year-olds on remand, 16-year-olds that had been sentenced, 17-year-olds then subsequently on remand, and 17-year-olds had been sentenced. And so there was a gradual process to bring the under 18s into the campus in a way that I think was gradual and was very appropriately done, but which created an anxiety among staff that they were not equipped to deal with and to manage the behaviour of what they perceived to be older and more serious offenders. And it was that level of concern, I think, that staff expressed, which caused or prompted the review of MAPA, which is the Managing Action and Potential Aggression Programme, which we use to de-escalate and to manage behaviour, including the physical interventions. And it was to give staff the opportunity to say, well, how would this look? What difference does it make? And how would this work in the context of what they perceive to be older young people? I mean, one of the challenges, of course, is that often the behaviour doesn't come from those that are necessarily bigger or more serious offenders. It comes from those with the complexity of need that's often more acute, actually, in younger children. So, but it's an example, actually, of the importance of addressing the concerns of staff and working with them so they feel better equipped and confident to manage situations, which, to be honest, can be very challenging and dangerous. And staff do get injured and hurt as part of their work. And so acknowledging that, I think, is really, really important to try and change the dial.
Thank you for the answer and staying right to the age discussion. We also have a question now from Ms. Webb from Ireland. To what extent are there challenges since detention facilities are extended to up to 18? And how do you see the challenges of transition for children aging out of detention and into the prison system for adults?
I think this is a huge problem. It's a huge challenge everywhere, and other countries have made much more progress than Ireland has. I know that some of the sentencing regimes in Scotland and the Netherlands and so on are much more generous to that point. It's a huge challenge because of the cliff edge that it currently presents. to children who in our system experience a progressive child-centered model, where their multidisciplinary services address their complex needs, and where they go to school all day in a very bespoke environment, and all of that. They're cared for by residential social care staff and so on, into a prison environment where they're one of multiples, not living in units of 5 or 6 landings. Much more dangerous environment for young people who are very vulnerable. So it's a huge challenge. In our strategy, we have committed to addressing, it was taking some of the learning from the Oberstein example into the care of younger adults in the prison system. And I think inevitably, we will see the age of majority being pushed up in the context of youth justice, so that the 18-year-olds and plus will start to be to receive the benefit of a much more adapted system, whether that's in a third place or whether it's in an extension of the Oberstein environment remains, of course, to be seen. But it's a huge challenge, and it really, I think judges need to be really thinking at sentence time about what their sentence actually means, not just for the 3 or 4 years where they might be in the adapted facility or the child-centered facility, but actually the reality that they will go on and spend many years, much of which will undo the work that's done in the more specialized environment. So I think it's a huge challenge.
Thank you for answering that. And like you mentioned, it's true that here in Austria, for instance, we have extended now the Austrian Juvenile Courts Act also to young adults from 18 to 21. So exactly. And yeah, maybe before asking it, there's another question also from our expert panel. Maybe before addressing this, I would like to ask Susanna Marietti, our next speaker, if she still has the time for like an ask question to Ursula.
Thank you so much. No, everything was very clear and very interesting. No other question. Thank you.
Perfect. So you still have 5 minutes to wait. Would that be fine? Yes, perfect. Then Helmut, you wrote me that you have a question to Ursula.
Well, yeah. Hi, Ursula. Good to see you. Well, actually, to some extent, it was addressed already, because I was wondering about the situation of young adults in Ireland, because in terms of quantitative issues, also in Austria, that's actually the bigger group. And so all these developmental aspects, of course, do not stop at 18. And young people get older. And as you have already also mentioned, Hauke, in Austria, we have the possibility to extend many of these special considerations to young adults up to 21. Nevertheless, it is a big challenge in terms of, especially also aftercare, release services and things like that. So perhaps just quickly on, to what extent also in Ireland are there some particular policies under development to address the situation of young adults? And second to that, because that's also a discussion or something going on in Austria right now, we had also kind of a centralized approach. We had one main prison in Lower Austria for juveniles, and this is now going to shift, because one of the practical criticism was that this centralized approach made it difficult on a practical level, because parents, for example, if they wanted to visit their kids, had to travel all over Austria just to meet them. And there's now discussion to make it, or to re-establish it in Vienna, for example. At the same time, there's this difficulty. You have all these kinds of specialized services and policies available, like you in Oberstein. How do you deal with that kind of challenge? Not to make it too difficult to practically reach those kids there. Thank you.
Yeah, I mean, I would say in relation to the older cohort, the younger adults, that what was really important when we transitioned the 16 and 17-year-olds out of adult prison was to reduce the population simultaneously. So really deliberate use of diversion at all stages. And we're seeing that now with the introduction of cautioning, police cautioning for young adults. And so that process is underway, but will take some time. As you say, it's actually a very significant part of the prison population, and at the 18 to 21-year-olds. So it's going to take some time and really deliberate strategy to bring those numbers down to the point where we have that in place. The other point is well made as well, and there was a lot of, at the time that the decision was being made to have just one facility, I objected and believed that we should have something of a spread of facilities, but the argument was made at the time that the need to centralise such specialist services was the only way it could legitimately and justifiably be provided, and I see the value of that in what we now have, and not least given that our numbers are really quite small. You know, they do push up to 40 at times, but in a 5 million population, that's not bad going. And I think the ability of the campus to provide the range of multidisciplinary services and supports, the specialism that's now there is really unrivaled in my view. So I think we have to do much more to engage with families. Families are involved in the care of young people in Oberstown all the time, but of course that's not evenly spread, either because the families don't have the means or the capacity to travel long distances, or the families themselves are just under such pressure that it's not feasible. We have used Zoom very successfully in terms of increasing levels of contact, and young people can reach out and can have phone calls and Zoom, you know, there's very flexible and generous communication permitted with families. So that does compensate in some way, but it's not ideal.
Thank you for the question and the answer again, Ursula. We have more questions. Unfortunately, we don't have the time to answer all of them at the moment. I would like to ask our colleague from Egypt again to please be more specific with the question, and then we can address it later on. And we also have a question from India. Our colleague has already answered to that question, that we will address it maybe later because it's not related to a specific expert. So dear Ms. Singh or Mr. Singh, I would like to mention that we will try to address this question in the next round of Q&A. With this, thank you very much, Ursula, for your valuable contribution. And yeah, I would now like to welcome the national coordinator of the Associazione Antigone, Susanna Marietti. Thank you for being with us. Antigone was founded in 1992, and like the heroine of the Greek mythology, the association Antigone also fights for justice, and more specifically for the protection of human rights for persons deprived of liberty and the prevention of torture. Antigone is also the leading organization of the European Prison Observatory and is a long-standing partner of the Boltzmann Institute of Fundamental and Human Rights. Together, we have published a handbook series of NPMs and are currently implementing the project Justice for All Together. Most importantly, regarding the topic today, is that Antigone conducted the monitoring of, I think, all 17 youth detention centers in 2022 and published reports about it, which are accessible online. Susanna Marietti herself supervises all the different areas of work of the organization, in particular prison monitoring, advocacy, campaigning, and strategic litigation. She is also a member of the General Assembly of the World Organization Against Torture, OMTC. Susanna, thank you for joining us and sharing your expertise today.
Thank you for inviting me. Just a few more words about my organization. Since 1998, we have been authorized by the Ministry of Justice to visit all adult prisons facilities with the same power that the law grants to the members of the parliament. And 10 years later, in 2008, we were also authorized to visit juvenile prison facilities, which depend on another department of the Ministry of Justice. There are slightly less than 200 adult prisons in Italy and 17, as you mentioned, juvenile prison facilities. We can also enter prisons equipped with video cameras so that we can also document life inside through images. And after each visit, a report on that single prison facility visited is published on our website. And once a year, we publish a report on the Italian prison system as a whole, which contains qualitative and quantitative analysis and elaborations, and is the result of our direct observation. And before addressing the specific issue of the disciplinary system within youth detention facilities, I would like to quickly try to offer an overview of the functioning of the Italian juvenile criminal justice system in order to provide some framework. First of all, it is important to take a look at the numbers. Right now, we have over 14,000 young people in the criminal justice circuit. Of these, less than 500 are in prison, 3.5%. We are therefore talking about a rather low percentage. This is mainly due to the Juvenile Criminal Procedure Code that came into force in 1988, which offers the judge a wide range of opportunities to avoid imprisonment. Until then, there was only one code of criminal procedure that applied to both adults and juveniles, and that dated back to the fascist era. After a long cultural debate in Italian society since the 70s, and after a series of important rulings by the Constitutional Court on the subject, a specific code of criminal procedure for minors was approved. Its philosophy is to privilege an educational model over a punitive one. The juvenile criminal trial, unlike the one for adults, does not limit itself to reconstructing the fact of the crime, but has as its main objective to assess the personality of the juveniles and their socio-family context, so as to prepare the most suitable individualized programs for them. As early as 1973, the Constitutional Court stated that the educational needs of the child must always precede the demand to subject the child to punishment in the state's scale of values. The Code of 1988 tried to incorporate this principle. Over these years, we have actually seen achievements in terms of reducing juvenile incarceration. The vast majority of young people subjected to some criminal measure are therefore outside prison. Some are free on the territory, subject to court orders to be followed and supervised by social services. Others are in home detention. Still others are placed in a shelter home. While there are 17 juvenile prisons throughout Italy, as we mentioned, there are about 600 shelter homes housing young people in the penal area, only 3 of which are public, while the others are private ones accredited by the Ministry of Justice. We can somehow say that the disciplinary regime already starts here, outside prison. There are basically 2 situations in which a behavior considered to be improper outside prison has disciplinary consequences. The first concerns a very particular type of probation provided for in the Italian Code of Juvenile Procedure. If the judges assess that it is in the best interest of the child, not only not to go to prison or to some alternative measure, but not even to be tried, they can suspend the criminal proceeding after the first hearing. They completely renounce prosecution and the ascertainment of the truth. The child is entrusted to social services with a program to be followed for a period of up to 3 years. This can happen regardless of the type of charge, even for the most serious offenses. If at the end of the set period, the child has followed the program satisfactorily, then the judge declares the offense extinguished, as if he or she had never committed it. In this context, however, the possibility of a disciplinary sanction is provided for in the event of serious and repeated violations of the program and the prescriptions given. The suspension of the trial is revoked. The revocation rates are around 7% each year. The other area outside prison in which disciplinary sanctions apply is that of precautionary measures. In particular, there is a provision that must be mentioned, especially because of its very recent pejorative reform. Until 1 week ago, it was the case that young people subjected to a precautionary measure in a shelter home who behaved in a manner deemed inappropriate were sent as a punishment to prison for 1 month. This punishment could only be ordered if the young people were charged with offenses for which a prison sentence of up to 5 years is prescribed. Recently, the rule changed when a government decree was converted into law. The 1 month limit has been lifted. In the event of conduct considered to be improper, the precautionary measure can be permanently converted into custody in prison. And the maximum sentence for which this tightening of the measure can be ordered has also been lowered to 4 years. The same decree law introduced another provision that has the character of a disciplinary sanction. In Italy, persons who have committed the offense as minors may remain within the juvenile criminal justice system until they reach the age of 25. After this limit, they must be transferred to the adult system in an adult prison if they are detained. The new decree provides that in the case of young prisoners over 21 years of age, who by their behavior disturb the order of the prison facility or create other difficulties, the wording is rather vague, which is obviously a problem, the warder can have them transferred to adult prisons. Such a transfer can have very heavy consequences on the lives of the young adults, taking them away from the educational programs they were following and throwing them into a far more problematic adult context. I mention all this because it has to do with the topic of our meeting, but also because it is important to be aware that the Italian juvenile criminal justice system, which in recent decades has been a model for the whole of Europe, is now under attack in its founding principles. As in other areas of criminal law, the current Italian government is carrying out a series of legislative interventions aimed at tightening the repressive reaction on the basis of individual dramatic events that have received much attention in the media, but which are not indicative of any emergency. For example, if we look at the data on juvenile crime over the last 10 years, we see that there is no emergency in this area. Let us now go inside the juvenile prison facilities. The law regulating the Italian prison system in general dates back to 1975. This law contained a transitional rule that established its validity also for juvenile prisons until the legislator provided for a specific penitentiary law. Antigone campaigned for a long time on this issue, arguing that the management of children and young adults in detention could not be the same as for adults, since juveniles have specific problems and needs. It has taken 43 years for this to happen, and only partially. In October 2018, some specific rules for juvenile prisons were introduced, but they do not cover every area. For the areas left uncovered, the 1975 law continues to apply, which also applies to adult prisons. With regard to the disciplinary system in particular, the list of possible infractions has not changed. Thus, what applies to adults continues to apply to juveniles. The list includes very minor infractions, for instance, keeping the cell untidy, and the serious ones, escaping or trafficking in prohibited goods, such as weapons or drugs. but it also includes infractions that are not defined exhaustively, such as harassing behavior towards the community or offensive behavior towards prison staff. It is obvious that this leaves ample room for prison police or operator to report prisoners. Moreover, the law explicitly states that disciplinary sanctions are also imposed in the case of unsuccessful attempts at such infractions. While the list of infractions has remained the same, the list of disciplinary sanctions that can be imposed in juvenile prisons has changed, although not radically, with the new 2018 law, and is therefore now different from that of for adults. The sanctions provided for in juvenile prisons are of four kinds. One, oral or written reprimands by the director, which are similar for adults and juveniles and have an effect on access to alternatives to detention. Two, carrying out restorative activities aimed at repairing the damage caused. Three, exclusion from recreational activities for no more than 10 days. Contrary to adults, juveniles cannot theoretically be excluded from sports activities. Four, solitary confinement, which unfortunately remains also for juvenile detainees. Solitary confinement as a disciplinary sanction is called exclusion from common activities, and in juvenile prisons can last up to 10 days, while in adult prisons up to 15. The law states that during solitary confinement, there must be no restrictions on normal living conditions other than those functional to the reasons for the punishment. Furthermore, the sanction of solitary confinement does not preclude the prisoner from having visits from family members and other authorized persons. Solitary confinement should be reserved for the most serious infractions. However, the law explicitly states that it can be applied if the inmate has already committed the same offense, however minor, within the last 3 months. Therefore, young people in prison could be subjected to solitary confinement if, for instance, they are found repeatedly with their cell untidy. But fortunately, as we will see shortly, this does not happen often in practice. Another relevant aspect of the 2018 reform concerned the composition of the disciplinary board. In the past, the medical doctor was part of the board. This meant that the doctor, who had to establish a relationship of trust with the young people and collect even their most intimate confidences, was the same person who had to decide on punishments, together with the prison warden and the educator. The very effectiveness of healthcare was put at risk because the young prisoners lost confidence in the doctor. Fortunately, the doctor was excluded from the disciplinary board and replaced by an honorary magistrate from the juvenile court. Finally, to complete the picture of the disciplinary regime from a normative point of view, we have to look at the interpretative provisions on the new rules issued by the Juvenile Justice Department of the Ministry of Justice at the beginning of 2020. They affirm, in particular, with regard to disciplinary sanctions, one, that these sanctions must always take into account the personal situations of the juveniles and that there cannot be a one-size-fits-all approach. Two, that the disciplinary system must aim at conflict resolution and therefore must immediately provide for the intervention of the prison educators. Three, that during isolation, periodic interviews with the prison workers must be provided for, and whenever possible, school, training, and religious activities must not be interrupted. This is therefore the general legal framework governing the disciplinary sanctions regime in Italian juvenile prisons. However, our activity of prison monitoring shows that practice does not always conform to this framework. There is a lot of difference as to how disciplinary sanctions are applied between one juvenile prison facility and another. On the one hand, there is much more homogeneity with respect to the type of infractions that are sanctioned. For the most part, these concern fights or quarrels between young inmates, often of different nationalities. At the moment, 53% of prisoners in Italian juvenile prisons are foreigners. This is obviously a problem of selectivity in our system, which it would take too long to go into here. Almost all the young foreigners come from North Africa, in particular Morocco, Tunisia, Egypt. Many are minors without any relatives in Italy who have arrived by sea and who are often accused in our country of being smugglers. The real smugglers ask these young people to keep their hand on the helm or to distribute water on board. At the end of the journey, they are identified as smugglers, while they are twice victims. There is obviously great suffering in them. It would therefore be very important to manage the relations with these young people through dialogue and listening without resorting to disciplinary sanctions. These young prisoners often do not speak Italian and have no tools to understand what is happening to them. It would be crucial to hire linguistic and cultural mediators to prevent internal conflicts instead of relying on the disciplinary regime. It must also be said that in Italian juvenile prisons, there is a larger use of psychotropic medical drugs. Foreign young inmates in particular tend to be addicted to them. Psychotropic medical drugs often serve as a substitute for drug addiction. The young people ask for them, and unfortunately, the doctors provide them with the consent of the prison authorities. This makes it easier to manage the internal order. However, it happens that as soon as the drug wears off, the boy or the girl becomes aggressive and asks for more. Medical drugs become the object of illicit trafficking among the young inmates. This fuels internal conflict and leads to new disciplinary sanctions. If these mechanisms were stopped, there would certainly be a reduction of the sanctions imposed. As for the latter, their application, as mentioned above, varies from prison to prison. In particular, some prison facilities experiment with restorative justice models as a substitute for the classic disciplinary sanction. Others add restorative justice to the sanction to the sanction used, while still others use only traditional disciplinary sanctions. The concept of reprobation is used according to two different models. The first, still too little tested, is the one that aims at the prevention of the problem and works on mediation. Some juvenile prison facilities provide opportunities for mediation and confrontation between young inmates to try a management of group dynamics aimed at avoiding conflict. The second intervenes after an infraction has been committed. Merely, the disciplinary board determines the activities that the young person must carry out within the prison to repair the damage done, such as minor cleaning or maintenance work. It is also to be noted that a completely illegal disciplinary sanction is in practice used: transfer. The law does not provide for it among the possible sanctions, yet operators in some juvenile prisons explicitly told us that it happens that young inmates are transferred as a result of their behavior that is considered improper. Again, the failure to manage internal relationships has a negative impact on the boys and the girls who see their rehabilitation program interrupted and have to start again in a completely new environment. Finally, regarding the use of traditional disciplinary sanctions, it must be said that solitary confinement is still widely used. At every visit we make, we always find some young inmate subjected to disciplinary isolation. The modalities of execution vary from prison facility to prison facility. In some cases, juveniles are transferred to special cells. In other cases, they remain in their cell, but are not allowed out to participate in recreational activities or to eat with others. In some cases, they are also prevented from attending school, which should never happen. Although a different name is used, talking about exclusion from common activities and not isolation, we are still talking about something that is forbidden by international standards. The first reform that should affect the disciplinary regime in Italian juvenile prisons is the abolition of all forms of solitary confinement. We know how damaging solitary confinement can be, especially for the most vulnerable. Antigone, together with the Israeli organization Physicians for Human Rights Israel, coordinated the work of a group of experts to draw up guidelines for overcoming solitary confinement on a global scale. The result was the International Guiding Statement on Alternatives to Solitary Confinement, which was presented in private briefings to various international bodies, including the Committee Against Torture, the Subcommittee for the Prevention of Torture, various special rapporteurs, including the one on torture and the one on the right to health. Unfortunately, in Italy, given the current government, this is not the historical period in which we can hope to have reforms that look at respecting the rights of detained persons, whether adults or minors. Thank you.
Thank you, Susanna, for this very comprehensive picture from the Italian disciplinary sanction system, the legal framework, the practices, and the current issues. I would like to quickly ask Silvia and also our co-moderator and Helmut if it's okay for all of you to extend the meeting for 15 minutes, because there are some questions also to Susanna.
Sure.
Any objections from any side? Yes, then yes, Roberta, you raised your hand. No?
No, everything is fine for me.
Perfect. Then I'm happy that we can take the time to also address some questions to Susanna, and I actually hear from our second Italian expert, Silvia Randazzo, who will actually speak afterwards as a final speaker, expert speaker today, that you have a question. Silvia, please go ahead if you would like.
Can you hear me now?
Yes.
Yeah, okay, good. Hello, thank you, Susanna. Thanks a lot. It's very interesting. I know Antigone quite well, and I know your work. It's really interesting to listen to you. One question, you talked about a very, worrying and interesting practice that is used as a disciplinary measure, the transfer of juveniles. Do you know if there are public data available on that? If this is reported in any way, or no?
No, because they are not formally justified with as a disciplinary measure. They are just transferred for any reason you can have a transfer because there are overcrowding or something like that, because it's not possible to formally justify it as a disciplinary sanction. It's not provided for by the law, but it is very common, as it was something normal that we go to visit prison and staff told us, well, there was some conflict between Morocco prisoners and the Libya prisoners, and we transferred 2 of them.
Okay. Thank you. But it's in your report, in Antigone's report.
Yeah, if you see our form on the single prison facilities for juveniles, you can read inside in which it's used to do this kind of transfers.
Thank you. Thank you.
And thank you for this question, Silvia, and for answering it, Susanna. One last question I would have is, because in the report there was written that some institute tried to systematize the intervention of restorative justice, as you have mentioned. Are there any special funds that allow for the structural implementation of such approaches, or how is this financed?
This year, we find in the budget law there are funds specifically allocated for juvenile justice system, for restorative justice, 9.5 million for 2024. I think that probably most of them are outside the prison, because juvenile justice, I would say, was the area where restorative justice first entered Italy, not in prison, but outside. It probably has something to do with the fact that the juvenile trial does not provide for the possibility of civil actions. So restorative justice was a way to give the victim some role. As early as 1988 in the Code of Criminal Procedure, under that particular type of probation that I mentioned in my speech, and which in Italian is called messa alla prova, and we talk about high numbers because it is the most used measure, more than 5 times as many people in juvenile prisons. Regarding messa alla prova, it is said in the law that the judge can give prescriptions aimed at repairing the consequences of the crime and at promoting the conciliation of the juvenile with the victim. Recently, a more explicit reference to restorative justice has been introduced, but we already had the concept, and there were and still are juvenile criminal mediation offices around Italy, funded by the Juvenile Justice Department. Restorative justice works and groups are also organized within prisons, as I mentioned, but probably Silvia Randazzo will certainly be able to tell us more about this.
Yes, exactly. This is why I wanted to already come to this question already a little bit referred to the last section today. Before closing the section 2, the national disciplinary sanction system, I would quickly like to still address the question from India, which we had some time ago. If there is someone from all the experts present who would like to answer this, please go ahead. At this from India was a comment that we have segregation units based on medical conditions and emergency, wherein the juveniles can be isolated for days to a week. However, during the segregation period, cases of abuse have been reported many times, and there has been the suggestion of recordings of proceedings, but confidentiality of the child usually is taken as a shield by the authorities against it. Does anyone have a comment on this, or from a national
Can
system?
I just, I think
yes.
what they're anxious about is that the facility is using that against recording of the circumstances, the treatment of the young person. I don't think there's any legal reason why that would be the case, to be honest. Obviously, it depends on the local context, but all of the safeguards, I mean, recording is a very limited safeguard in any event. It's important but it's procedural safeguards in terms of engaging with the young person, ensuring that their treatment is monitored, they have healthcare, they have access to family, they have access to their lawyer, they have access to education, and outdoors. These are all in the international standards, and I think are and should be the focus. I don't agree that any there should be any hesitation to record on the basis the young person might breach their right to silence. I just think that doesn't really arise. And I'm happy to talk offline to our colleague and chat about it further.
Thank you, Ursula. And I can also maybe mention here our project Procedural Rights in Police Custody, because we have published recently a fact sheet on audiovisual recording in police custody, where we did a comparative analysis in several countries. So maybe my colleagues can post a link to this fact sheet also in the chat. Due to the time constraints, I would now like to thank all the national experts, Susanna, Ursula, and also Manuela Albl. And we would come to the last part of today's webinar, section 3. There will be an expert conversation afterwards, an analysis of the key takeaways also by Roberta and Helmut. So welcome Silvia Randazzo as the last expert speaker today. Silvia is a criminologist and independent consultant specialized in child justice and restorative justice, and a PhD researcher on diversion practices in Europe with children suspects accused of crime. Currently, Silvia is collaborating with Penal Reform International on a mapping of tools and mechanisms of data collection, monitoring of violence against children in criminal justice detention facilities in the EU. As an independent consultant, she has contributed to several European and international multi-country projects, including the already mentioned UN Global Study on Children Deprived of Liberty, specifically to the chapter on children in detention in the administration of justice, and collaborating with the UNODC Global Program to End Violence Against Children, and with the European Forum for Restorative Justice. So she has really a very big expertise in this field. And most recently, she has written a blog post about monitoring violence against children in detention. Today, she will inform us about some basic concepts and framework to restorative justice and provide us with some ideas on the use of restorative justice within detention, and in particular as an alternative to disciplinary measures. Thank you, Silvia, for joining us today.
Thank you. Thank you, Hauke. Thank you, Roberta, for the invitation. I will immediately share my screen. Oops, okay. Yeah, you should see, right? So yeah. So yeah, thank you so much, Hauke, for this introduction. And I'm conscious of the time, so I will try to be brief. We always promise that we never manage, none of us, but I will do my best. And it's not necessarily an easy task, as my task would be to introduce you to some basic main core concept about restorative justice. As it is a very well-known concept at this stage, but it's not as mainstreaming, I think, as we would wish it was. So I'm going to introduce you to some key definitions of restorative justice and ways it is used in the criminal justice system, and then I will go quickly into the bit of the focus of this webinar, so the application or potential application or current application of restorative justice within child detention facilities. So what is restorative justice? This is a big question that would require another whole webinar, but to give you just for the people that never heard of this concept, of this expression, restorative justice is relatively new, but it's not new anymore, but it's a different, let's say, it's a different approach compared to the traditional one to justice. So it's an approach of, as you can see from this definition from the European Forum for Restorative Justice, is an approach of addressing harm or addressing crime while looking mostly at the harm done by the crime through engaging all the parties affected. So we talk about the victims, the offender or the suspect, and the community at large. So it really depends then on the type of restorative practice we refer to. with the objective to reach an agreement or a common understanding, which we'll see, or maybe we won't have the time to see, but the agreement is not always the necessary conclusion of a restorative justice process. But anyway, the objective of a restorative approach, restorative meeting, is to really at least get to a common understanding of what happened in the episode of the crime, so how the harm or the wrongdoing can be repaired, and how can justice be achieved through the lenses of all the people involved. So in a way, the crime or the wrongdoing that happened goes back into the hands of the people that are directly affected by the facts. In a nutshell, this is what basically, in a way, differentiates the main aspect that differentiate the restorative justice from the criminal justice, the traditional criminal justice. And you'll find this in one of the first conceptualization of restorative justice by Howard Zer, a scholar from Canada, in his book Changing Lenses from the 90s. Where you can see again what I just briefly mentioned. So the restorative justice approaches and practices, the focus is not anymore the violation of the law, which of course is still important, don't get me wrong, but it's the focus just changes and goes to the harm that has been done by the crime, by the people involved in the crime, and being the focus on the harm, so the focus also shifts from the law to the people. So from the state to the people includes all the victim or victims involved, and gives much more space and much more voice to the people involved, all of them. So the victims, the offenders, and the community members that are in one way or in another affected by the crime, by the harm, by the wrongdoing. So the specific need, the specific focus of restorative practices are the needs of these people involved, their voices, and how then they will decide together how to resolve to restore the relationship, and to resolve the issue that came up from the commission of the crime. And again, as I wanted to also add that this is a very brief, and it's a very maybe a simplistic way of introducing some of you to restorative justice, but I will refer you to some further references if you like to explore more. The forms that restorative justice can take in the context of the criminal proceeding, but also outside the criminal proceeding, are mostly three. The most common, or at least the big, let's say the big, the macro groups that include victim offender mediation, conferencing, and the peacemaking or sentencing circles. So victim offender mediation is the most common, at least in Europe, across European countries, and is characterized by the meeting, mostly by the meeting between the victim, the offender, facilitated by a mediator, so by a professional facilitator, mediator, or more than one, depending on the jurisdiction. Conferencing is a bit of a larger kind of meeting where the people involved are again the victim or victims, the offender, and then the facilitators are always there, but they can be accompanied by other members of the community that are in different ways affected or involved in the crime or in the facts. And then we have the peacemaking or sentencing circles, or more generally called circles. So where you have a bigger groups of people, like you could see, and this is one of the instruments used also probably in prison or in detention facilities, where you have bigger groups and heterogeneous groups of people that meet either in reference to a specific crime that happened, or in general to some more to bigger conflict that involves the community or a certain community at large. In the context of the criminal proceeding, and as we'll see in a moment, supported by the legal framework, legal standards at European international level, restorative justice in the forms that I just mentioned to you can be and is encouraged to be used also as in different stages, at all stages actually of the criminal proceedings. So it can be used as a diversionary measure, or part, so it can be either per se a diversionary measure, but it can also be used as part of a diversionary program. As for example, Susanna was mentioning, in Italy, the diversion measure includes the so-called messa alla prova, includes a component of restorative justice that can be applied, and the same in many other countries. It can be used as an alternative to detention. So after the sentencing, as a sentence, as a response to the crime. It can be used also as a one of the many components of a probation program or educational program that can be also can go in parallel with the formal sentence, and so with including detention. But the further interesting thing that applies mostly in the context here we are talking about is that restorative practices can be applied also outside the criminal proceeding. That's where we talk about restorative approaches, restorative practices, and it is used and it can be applied and it is used. There is experience, a lot of experience coming from across countries of restorative practices used in schools, in communities at large, for example, in neighbor conflicts or bigger kind of communities conflicts, and in prison. We'll see in a moment how it can be used and it is used in detention context. So basically, restorative justice can and is used everywhere where there is a conflict or a potential conflict. So everywhere people are involved. So going then now to the youth detention context, we saw in the previous presentations that detention is a highly complex environment with high level of conflict or potential conflict. So the previous speakers gave an idea of the complexity of this environment and the different aspects that can make this environment very complex, beginning from which, especially talking about youth detention, the fact that we are aware that less and less children are in detention, especially if we look at Europe. So this is a great news. But the counter, let's say, aspect of this is that the children that are still in detention are the most vulnerable and the most problematic, and they come already into detention with a lot of baggage, let's say, so also a lot of trauma and issues from outside that need to be then dealt with in detention. The other let's say, level of complexity comes from the different forms that conflict in prison can take. So when we talk about conflict or we talk about violence, we refer to many different kind of violence. It could be between peers, which is probably the most common in youth detention context, but also between children and young people and the prison staff. We can also look at violence or conflict within the staff, so between staff members, or forms of violence against the structure, and so on. There is of course, in every kind of conflict, there is a victim or more victims. But in the youth detention context, we saw from the presentation so far, the approach tends to be quite punitive. So for many reasons that we are not going to look at anyway, our speakers already provided some insights on that, but this is the reality. And the punitive disciplinary sanctions are mostly used. Let's say, I could simplistically say that they are often the easiest one to do, also in response to the means that the staff has to respond to this kind of conflict. So, but we know from research also, as Mariama mentioned at the beginning, that sanctions like punitive sanctions like solitary confinement, but also many other kind of violent or punitive, kind of disciplinary sanctions produce further harm than actually reducing and making the environment more livable, if you want. So this is a context, very, very complex context where restorative justice has anyway a great potential. As I said, the use of restorative justice, and I will not stop too much on this, but just to give you these references as a legal framework, restorative justice is supported across by international standards. We'll see in the next slide. But in Europe, these are the two main instruments that support the use of restorative justice, including in prison. And it is very interesting, the directive of the European Union on victims that makes explicit reference first to restorative justice and also to victims within the detention system. So it's interesting for once also the attention was on the victims within the prison. And while these are all or at least the core international standards that provide support to the use in general of restorative justice with children. But I leave you and also will share the slides, so I will not go into much in details about that because I want to go to the main focus of this discussion, which is the use of restorative practices in detention specifically. So there are different ways where restorative practices can be used in detention, including in youth detention facilities. These are three main kind of practices that so that they don't focus necessarily on the response to some wrongdoing from the child or from the young person in detention. So, and they are practices that are used not massively. Still, we are talking about pilot experiences. Is less spread and less developed still in the restorative justice also field. But still, we have some interesting practices across Europe. For example, in Belgium, the Netherlands. Some other examples from Germany, and later I'll give you just a few snapshots about countries where these practices are used. But so just to give you also an idea of what kind of programs we are talking about, we have the victim awareness programs, victim offender mediation, and also the kind of way to bring the community together with the community within the prison or vice versa. So in a nutshell, victim awareness programs are the kind of programs that see victims come together and meet. Group of victims comes together to meet a group of offenders, and they are not necessarily victims and offenders of the same specific crime, but they've been maybe victimized of the same category of crime, let's say. So we have a group, for example, of victims of robbery that will be prepared obviously by professional facilitators to then meet groups of robbers or people who are convicted for robberies and are in prison. And these victim awareness programs are held in prison and are facilitated by professionals. Victim offender mediation, as we mentioned in the beginning, this is one of the most common forms of restorative justice, and they can be used also in prison. So you can think of someone that has been convicted for a crime and is in prison, and he or she asked to have access to restorative justice, or he or her victim asked to access restorative justice. So again, the professional facilitators will prepare and facilitate the meeting between these two people. And with the third group of practices, we refer to some opportunities of community works, where the offender can work to repair some damage towards the community and within the community. When we look at restorative justice or restorative practices used as alternative to disciplinary sanction, we narrow the focus a bit, and so we need to look at ways. Basically, we're looking at ways to resolve conflicts restoratively. So to respond to discipline issues or to disputes between inmates or between inmates and staff restoratively, which requires also something, as Ursula mentioned before, requires a long way, requires a long also cultural shift. It's not something that happens from one day to another, but it requires to create, really to build on a restorative environment, which is quite an oxymoron compared to what we when we look at detention. So but it's a dilemma that we will have to deal with, and it can anyway help release some pressure inside the detention system. Examples of practices here, as I mentioned before, I was going to give you some snapshots of practices that are used in Europe, since we will not have the time now to go into the details of all of them, but just to, and in the slides you will find some links, so hyperlinks to the resources and to some videos also. In the main message I want to share here is that in some countries there are these pilot experiences where conflict or disciplinary issues are resolved when, like, bringing together the parties involved in small groups, or like in conferencing, or really creating in a much bigger scale, creating more a sort of restorative environment where much bigger work is done. So where experts and facilitators, like in the example of England and Wales, for example, they are called to intervene and to work on the the specific youth detention center, to work with the staff and with the children, and to really create the environment that is then conducive to resolve conflicts in a restorative way. I also make here reference to the experience from the school context, which is of restorative practices in the school context, which I think is very much relevant in this specific area. And of course, schools are not as complex as a prison environment, but there are some elements that can definitely bring positive change from which we can learn. Then to go towards the conclusions, so why we should go really to invest in more restorative justice or restorative practices in prison is because we have quite a lot of evidence, and we have research, at least on the use of restorative justice in other contexts, or in schools, as I mentioned, or in the criminal proceedings, or in the few pilot practices that we have in prison. But we do have evidence that these restorative practices bring some actual positive change. So they bring quite high level of satisfaction between both in victims and offenders. They do help restoring relationship, and they also facilitate, of course, reparation. And this is also quite interesting in also thinking about the victims awareness groups, for example, that I was mentioning before. They can really also help. They can contribute to an overall environment within detention that promote empathy and dialogue and respect. So also indirectly kind of having an impact, a positive impact on life in detention, in the detention community within the actual facility. And here I put a reference to the very interesting movie that just came out this year, and I really recommend you to watch it if you want to know more about restorative justice. And this is the first, I would say, the first mainstreaming kind of movie. It's a French movie, very well done, and it's extremely well documented. So it was produced together with the Institute of Restorative Justice in France, and with the support of the European Forum for Restorative Justice. So, and it represents, it speaks about these groups and the impacts of restorative justice and the work that facilitators do. Specifically with the focus on restorative practices used in prison. Again, some of these benefits I already mentioned, but one that maybe it's important to reiterate is the fact that is the emphasis on the impact of restorative practices in restoring relationships, which is a particular importance when you think that the people affected in this case by conflicts are also people that are going to continue living together and continue experiencing same or similar level or types of conflict. Of course, this is much more difficult than it looks, so it's much more complex, and I'm afraid we won't have the time again to go into these dilemmas, but it comes again to a bit of the oxymoron between prison and restorative justice, which represent really two completely opposite ways of thinking, and but they can definitely in a way they can coexist, and we think as restorative justice researchers and that restorative practices can help and improve at least the living within detention, if you really, for those that really have to be there. So to conclude some and to really quickly, I realize, but in a way to close with some positive notes, in a way for some encouragement to keep investing and researching on these practices and on the impact of these practices. We really need to, at first thing, to keep advocating for the use of detention at the last resort, and you see it's a circle. So restorative justice or restorative practices in detention don't mean that we are kind of promoting life in detention because it's restorative. Obviously, this is never going to be the conclusion, but it's just a way to really provide safety within detention for everyone that is there, so the children, but also the staff and all the people involved in the conflicts within such complex environments like detention. So that requires a lot of training, a lot of awareness raising outside and inside detention, because as we heard already, detention doesn't come in a vacuum, but it's very well embedded in a society, in a community that we need to also, within which we need to raise awareness about different ways to solve conflicts and to resolve episodes of violence or disciplinary kind of situations. So yes, I think I will leave you with that, and I'm open to questions if any.
Thank you very much, Silvia, for this very interesting perspectives on restorative justice in general, but also in the prison context, and also regarding as an alternative actually to disciplinary measures. Very interesting. I have already written down also the link to the movie on IMDb to maybe finish this day with watching that. Thanks for this. And I've also asked my colleagues to please post the link to Silvia's webpage, because she's offering also her expertise for diverse set of services, and you can also see there the all the publications she had made. I think reports, guidelines, and she also wrote articles on this. So please, my colleagues, post this in the chat, and then I will actually come to the questions. I would ask the audience and also the other expert to address some questions to Silvia. There is one in the chat already. Our colleague Ms. Singh from India has asked or commented actually first that they have been trying to push restorative justice in India before the Children Court, and face actually their constraints, and the state doesn't support it, and it continues within the criminal proceedings in a conventional way rather. And she has asked how restorative justice with respect to offenses against society or also the state is being implemented and executed in other states. Maybe Silvia, you know best, but also the national experts might be able to address this.
Yes, thank you, Hauke, and thank you for this very, very important, very complex question. But indeed, it's so to respond to the first. Sorry, I was. reading and it's been dismissed.
I did in the answered section.
Okay,
It's
no,
now.
no,
Yeah.
okay, yeah. First of all, in the first part of this question, that's where I think we really need to invest, and still in Europe, even if restorative justice has quite been developed and spread across systems, but we need to, I think, we need to invest and improve a lot in awareness raising within the communities, within society, within the state, so within governments, and of course it can really depend on the historical moments. So there are more, let's say, I refer to for my colleague from Italy was saying earlier about the historical moment. For example, there are some historical moments that are more appropriate than others, let's say. But what we can do as experts and practitioners and researchers is really to invest and continue informing people. And you know what, something that I think I realize works very well in raising awareness about restorative justice is to show people's stories, just to really show the stories of people that have participated in restorative justice processes. And we have a lot of interesting testimonies and videos that we collected in the course of projects that we can definitely also direct you to if you want to use it for training purposes or raising awareness purposes that are quite effective. And in reference to systemic violence or structural violence, as you referred to, it's also an ongoing discussion. And at the level of the European Forum for Restorative Justice, we have interesting working groups that are debating and discussing a lot about how to really use restorative justice in these cases, which is not yet very well established, but it's a movement. So if you are interested, you can definitely get in touch with the forum and to get to know more about what these groups are producing in terms also of discussion and debate.
Thank you, Silvia. Any further comments from other experts? From Italy and Ireland, actually.
So just one doubt with this. I think that you ask yourself a lot of time, you wonder about that. But, participation in the restorative justice processes should always be voluntary. But my doubt is that in an environment like detention, it is very difficult to have anything which is really voluntary, because the assessment of prison workers is too important for any prisoner in terms of access to freedom, alternative detention, and so on. And aren't you afraid that there might be a form of obligation that the prisoner feels anyway, that forces the prisoner and the young person to perhaps meet the victim when he or she is not ready and would not want to do so?
Yeah, definitely. Definitely that's a big risk, and it's one of the risk in the dilemmas that I couldn't cover in my, but it's definitely in there, and it's that's where I refer to a very highly complex environment also regarding this. What I would respond is that we shouldn't limit ourselves just because of this risk, but there are ways to overcome, or at least to I would say to mitigate or to help mitigate the risk and in the long term avoid this risk. And I think this is where I was referring to a long process. So it's not just that we go into the prison tomorrow and we ask or we go even with the professional facilitators to say, okay, from tomorrow we are going to address all the conflicts with the restorative justice process. So you like it or not, you decide if you want to participate or not, but it's actually a very long, I would say, I see it as quite a long process of sensitization with the staff first, with children as well. So in two parallel ways. So to inform both all of them about these possibilities, but also to accompany these processes with, work on empathy, on communication skills, so all of this kind of really, we are talking about quite maybe a revolution of the system in some ways, in some instances, but probably worthy the effort in the long term.
I was just going to add, Hauke, that, and Silvia knows this, we've had this conversation, that we have restorative practice as one of our sort of underlying themes in the detention centre here. And it works very well because it sits with general ethos of problem solving and bringing people together and giving young people, I suppose, the responsibility as well as the opportunity to come to terms with with the others that they have disagreements with, or who they might have harmed, and so on, including with staff. It's very much part of the recovery process from serious incidents that people are supported to come together in a restorative manner. And I think but as you suggest, I think it can't sit in isolation from a different type of environment or ethos. It really has to fit with the general supportive environment that exists for both staff and for young people in detention facilities. But it can be part, for example, of, we have experience of the young people in their residential units adopting charters where they agree the sort of rules of engagement between each other about mutual respect and how decisions are going to be made and how they're going to recover when they have disagreements, which they do. So I think it's part of a wider context as well, where it works best.
Yeah, thank you. If I may add also to that, it's I think one of the big issues in some countries also is overcrowding, for example, or the big numbers, and this definitely they don't help this kind of process or works. I mean, it's best in an ideal world, of course, but it's what I think we should at least aim at, is to have smaller units or smaller groups of people, of children that can work more closely with staff that can really know them better. So that's why it's a process where things need to be in a way structured a bit differently than they are now especially in some countries.
Yeah, thank you very much for the insights also from Susanna and from Ursula. And there's another question actually from one of our experts. And yeah, before writing the question, because it comes from Mariama, I would like to once more also express our appreciation of being a member of the CREAN network. So thank you very much also to Genova, but also to the Child Friendly Justice European Network. So thank you also for the efforts to Brussels. And Mariama actually asked that for serious crimes, media can have a very negative effect on children's well-being. And do you think that media could play a role in supporting the use of restorative justice in youth detention facilities and promote stronger narratives in favor of children's rights?
Yes. Yeah, I think definitely is a huge, it's a big role. And I'm thinking now, for example, of Italy, where Susanna was mentioning some episodes of like great violence that were triggered an outcry in the media, and then it was about the same period, or was in like a similar, like close to the moment when the law on restorative justice also in Italy was approved. So in a way, the media were so poorly informed about what restorative justice is and what actually restorative justice means, that they produced a completely opposite effect than in promoting what has happened, because like then referring to these very violent crimes in a very disinformed kind of or misinformed way. So I think one of our task as restorative justice advocates or researchers is really to also have a dialogue with media and to training and sensitization with media, so to explain them all of this, to show them stories and to actually have them on our side in a way that they know what we are talking about, so they know what they need to or what they can support and how they can support proactively and positively this discourse.
Thank you for the answer. Are there any more questions from the experts or from the audience? No? Then, Silvia, also thank you. There's one more question popping up. Some information also from Egypt, so that they also try to implement the restorative justice program, but not a question. Thank you for this information. Then I would thank you very much, Silvia, also for your contribution into restorative justice. And before we finish this today's webinar, Helmut and Roberta will provide us with an overview, a wrap-up, and some key takeaways from all the presentations we heard today. From my side, my moderation role ends here. I would like to thank the audience, all the expert speakers, but especially my colleagues, Roberta and Manik from the CREAN network, and also Helmut and Charlotte from our institute. And I'm passing over the moderation role to Roberta. Thank you.
Thanks, Hauke, and thanks to the all speakers. It was extremely interesting. I look at Helmut, you were exchanging some messages. It's not an easy task to do now the conclusion of such a rich exchange. I will start with I would say a note that something that came, I was literally writing while listening to all of you, and there is a component that to me is putting the whole intervention together. And of course, I bring you to my field of expertise. For several years, I've been working on indicators to measure the implementation of children's rights. So in the chat, I'll share you a publication that is completely in open access that may be of interest, that on the basis of which we are together with those colleagues, we will publish a companion book in June 24 in the series of Springer, with a set of comprehensive indicators. And of course, among them, there are indicators, there will be indicators that are related to juvenile justice based on the chapter I just shared. A component that to me is emerging from all the intervention we heard today is related a systemic one, and has an impact, of course, on the process and the outcomes. To me, there is an issue, a challenge, a problem that is related to the conception of the system. It is related to the absence of the centrality of the child in the detention determination measures. Ursula Kilkelly was underlining that there is a large spectrum of different possible measures of detention, and the fact that some of them are completely a violation of children's rights, if I got it correctly. And the difference between being or not being in violation of children's rights is proportionally related to the availability, I would say, of the system to take into consideration the intersectional components that impose a consideration of the peculiarity of the single child. So if we don't mainstream the child and his peculiarities, his life experience, his ability, we will manage to identify something that fits that specific child. The little or no attention to the specific personal condition of the child in the identification of the measures is clearly to be emerged to be it says a lot, I would say, about the aim and the ability of the system to secure the child well-being during the measures. Some of the participants were talking about health, but that has impact on a lot of other components as well. So the well-being of the child during the measures, the application of the measure, and after, to secure to this child a better future. There is a very little about children's rights impact assessment components on the measures, determination of the identification of the measures that needs to be applied. The Austrian colleague from the Ombudsman office underlined that the importance of the pedagogical component of the measure to accompany and to empower the child in a respectful process of reintegration, of empowering. And Susanna Marietti was showing us an example that introduced of a system that introduced a more pedagogical approach to avoid detention. but still both of them, they clash with the limits of the resources and the structure, the importance of training of professional and pedagogical measure, but also on how the same professional can perform their role with a pedagogical approach in the implementation of the measures. So these, to me, are all strong indicators of the limits of a system that at the origin was set for adults, and we are struggling in adjusting it to children to set up this pedagogical or right-based approach. A component that was raised today by all of our experts in different moments and from different angles. And for this, I want just to underline how much I appreciated again your contribution to the discussion. Helmut, I hand it over to you here, I think. I'm sure you will point out a lot of other plenty elements.
Well, still, I will try to be short because we're already quite late. But in terms of takeaways, and I fully agree also what you said right now at the end, Roberta, some inherent limitations, how to make a concept which was not designed for children still adaptable to the needs of children and to their rights. I think we have seen those limits. Nevertheless, one takeaway for me is clearly that, as Ton has emphasized at the beginning, there is a stronger need not only for a child rights-based approach in general, but also for an access to justice approach inside detention, especially when it comes to disciplinary regimes. At the same time, and Silvia's contribution has emphasized that at the end, we have experience about alternatives in applying even restorative justice approaches inside prisons, and especially also thinking of the Austrian experience. Juvenile justice has always been a kind of a motor, a kind of a front runner of positive developments, of which the general prison system often has benefited. And I think the same could apply to this context as well. I think another takeaway clearly is the further need to work towards ending solitary confinement, as Mariama has presented with the position paper, and also Italy. Susanna, you have emphasized your efforts in this regard. On the other hand, I think it's important not to forget about the broader societal developments and policy developments. We heard of the difficulties in Italy in particular. We discussed right now about the importance of media and not losing the general public when it comes to implementing reform, which then would also make it possible perhaps to also have legislative changes to the better. We heard from the Austrian example about the importance of monitoring, and how difficult that actually is then to change existing rules and have something enshrined in law. On the other hand, and to end on a positive example, we heard about the Ireland best practice example, I would say, that change and cultural change is possible. It requires a lot of commitment by a lot of people, but nevertheless, there have been measurable benefits, and that should be a lightning example, for our continuous work on all these issues. Just a final aspect which came to my mind right at the end now, the role of schools. Again, not to forget about, one key message actually has been, ideally we prevent children entering into detention as such. Nevertheless, to sensitize them about how this system actually works. And here in this regard, I see a strong role also for schools. Not just to make people outside already of the prison system aware of how criminal justice basically functions, because I think our experience so far has been that most of the kids know about the United States prison system much more than about the Austrian system. But also when it comes to conflict resolution, and school could be a role model here, which already could emphasize some of these principles, which would then ideally also be implemented inside the prison system as well when it comes to like restorative justice approaches, etc. So these were some takeaways from my side. If I may just conclude saying that personally, and I guess I can speak for Roberta and CREAN as well, we're definitely interested in remaining engaged in that topic, remaining also in contact. I think also from the Child-Friendly Justice European Network, we will continue addressing clearly access to justice issues, including in the prison system. As Ton has mentioned, the stakes are high. The context is sensitive. Developments happen quickly, and we need to be vigilant and constantly engaged on that. So finally, thanking again CREAN, Roberta, Mani, for making this webinar possible. Thank you to all the speakers, Ton, Mariama, Manuela, Ursula, Susanna, and Silvia, for all your contributions, and thank you to all the participants, even across continents, which is perhaps one of the key benefits of having something online as a webinar. And a big thank you to my colleague Hauke and to my colleague Charlotte. Have a good day and a good weekend.
Thanks, Ursula. Thanks to all the speakers again.
Thank you.
Thank you very
See you
much.
all.
Thank you. Bye.
Bye-bye.
Bye.
Oh, I thought Helmut was staying with us. Can we stop?